construction of siding at Durga Chowk station, that the civil engineering and OHE works are likely to be completed soon, and OHE work will be taken up after obtaining approval from COE. However, even though Messrs. MRT Company have been approved by CSTA for undertaking SNT works, there seems to be no progress in actual execution. So I complained as way back in 2008 itself. SNT department has advised that the existing lever tram at Durga Chowk station cannot accommodate signals for all the private sightings coming up at the station. As you are aware, apart from your sighting, in principle, approval has also been granted by railways to Jawala Steel, Rungta Mines for construction of their private sighting at Durga Chowk. As such, it will be inescapable to go in for a panel of replace the lever frame which will serve the sidings of Messrs. Electrosteel Castings Limited and Torian Iron and Steel immediately. Add-on features should be provided to take care the requirements of other private sidings and when they come in force. Now, my lord, kindly comes to the last, my lord, paragraph. Since your new siding at Durga Chowk station, which is the gateway to Haldia Port Railway, cannot be commissioned without proper signaling, you are requested to please get in touch with CSTA immediately to obtain further details of the proposed scheme. This may please be treated as most urgent. So, my lord, I ask him that, my lord, there was, my lord, I just have to deviate a little. There was a writ petition filed by Torian, my lord, before this court, because they were not able to, my lord, get access, my lord, to a portion of the line, my lord, which leads in. So there was a double lining which was to be made. So when Torian left, my lord, we said that since they were the only people, all of the others had left because, my lord, they wanted exclusively, because the land was, my lord, around 7 acres. I think that was increased to, my lord, 13 acres, because once they left, the rest of it also, my lord, they had taken over. So, my lord, they said that, well, since we have taken over, we would also do the double lining, my lord, so that we have a better access to the Haldia port. Now, my lord, therefore, my lord, I write to him that, my lord, for the commissioning part which is to take place, you please talk to the respective department so that, my lord, this can be also ascertained and done. So, my lord, as far as the commissioning is concerned, it was only upon him to, my lord, to do the needful and to have the commissioning done as way back, my lord, in 2008 itself. So, my lord, 3 limbs which I have to look into, my lord. One is, my lord, the land which I have given. Second, my lord, is that, my lord, I have approved his plan. And third, my lord, I have also stated that you can commission it consulting with X department. That is all, my lord, as far as I am concerned, under the obligations of this, my lord, agreement. Now, my lord, kindly sees, my lord, a reminder letter is even sent to them, my lord, at page 279, my lord, for the commissioning purpose. This is dated, my lord, 2nd of December 2008. This is to recall in connection with the subject matter under reference. Please let this office receive and know about the proposed land plan and from your end showing the actual occupied area of the railway land as to prepare the proposal in favor of your siding, which is being delayed in connection with the agreement in between railway and you immediately. Because, my lord, the land licensing agreement was to be prepared, and that could not be prepared because, my lord, of this delay caused by them to give the, my lord, actual plan for the land on which they were preparing this entire unit. Now, my lord, apropos this letter of reminder, we again, my lord, write to them, my lord, at page 290, which is, my lord, the next volume, volume 3. Reminder. Whereby they accept, my lord, the change even to the extent that I had just, my lord, stated before, my lord, is that, my lord, they accepted that they would also do the signaling part. We thank you for allowing us to commission the siding. So, my lord, this is another acceptance from their behalf. They say that we have allowed them a commissioning. It is upon them now. We thank you for allowing us to commission the siding as per CE's drawing. So, my lord, we have approved the CE's drawing. However, we would like to bring to your kind notice the fact that the signaling plan of the said site at Durga Chowk has been approved till date, has not been approved till date, due to which we are unable to take up the signaling work. So the signaling work, my lord, they complain of that it was not given to, my lord, an approval to that extent. It may kindly be observed that connection of the proposed KOPT line from the date of issue of your above referred letter will not be practical, as it will take a minimum of 4 months to commission the siding from the date of approval of signaling plan. Hence, we request to kindly allow us to connect the proposed KOPT line crossover within 1 year from the date of commissioning of the siding, instead of 1 year from the date of your approved letter. So, my lord, they accept the second portion of the land also, and the second portion of the work also, which is, my lord, for the purpose of the signaling plan and for the double lining. And they say that, my lord, the time period should be considered for the crossover approval 1 year from the date of commissioning. So, my lord, the commissioning has to be done by them. It is not, my lord, upon me to, my lord, have the commissioning done. Because that part he accepts at the first paragraph, that approval I've already given to him of the drawing. Now, my lord, kindly sees. Cannot. Now, there is one thing I must show, my lord, from the letter of 290. Lord, you will remember when I will, my lord, I will again reiterate. In the award, the arbitrator holds that, my lord, this double signaling or the double lining crossover was never agreed upon between the parties. This is extra work. And this is how, my lord, I have committed breach of the agreement. This is the finding of the arbitrator. Whereas, my lord, it is their letter in 2009 itself which says that they have accepted it and they want to do it. And I have been, my lord, saddled with crows on this ground itself, that I have committed the breach of the agreement. Now, my lord, kindly takes one more letter, which is 299. Agreement, which is, my lord, 11th of November 2011, given by them again. Provision of minimum 500-meter rail track length on either side of the weighbridge will put the basic problem again to availability of land. Present acquisition of land for the siding is very difficult as cases for the industries. Some approved design for in motion weighbridge should be looked into so that the additional land is not required. As well, track length on either side is reduced from 100 meters. So, my lord, they accept this construction. They require a modification of that. This cannot be, my lord, in defiance of the terms agreed upon by the parties as held by the arbitrator. I'll show to my lord. They accept a modification. Agreement. Now, my lord, kindly takes the agreement, which is at 310. And, my lord, this is very important because the arbitrator holds the delay is from our end. Whereas, my lord, I have shown the correspondences which are part of the records before the arbitrator, that it is the, my lord, respondent herein who is asking for certain delays in view of the fact that they were not able to commission it, or, my lord, extend that amount of, my lord, support to the, my lord, construction due to, my lord, reasons which are attributable to them. Now, apropos that, my lord, agreement is entered upon between the parties, which is the land licensing agreement at 310, which gives the, my lord,
this will be third volume.
My lord, this is in volume, my lord, 3, my lord. I was showing volume 3, my lord. 310, my lord, which binds the parties, my lord. Arbitration clause dekha nahi. Arbitration clause আর ওই ক্লজটা যেটা ভলিউম 3 আমার এখানে 3 আছে 310 is volume 3.
I have volume 3.
এখানেই তো এই ক্লজটা আছে না, যে নোটিফিকেশনটার কথা বলা আছে, ড্যামেজ ক্লেম করতে পারবে না। Now, my lord, this agreement has, my lord, a retrospective effect from, my lord, 2007, from the day that I've given 2006, my lord, that I have given the land to them, and I'll show, my lord, they have also paid apropos that to me to the extent in 2000, my lord, 9. Now, my lord, this agreement is the agreement in respect of which the reference was made. Kindly see 310, my lord. License for temporary occupation of railway land for private siding, an integral and foremost part of related agreement for private siding for execution. Now, apropos this agreement, my lord, which is being signed between the parties, kindly see, my lord, very important clause herein. Notification is, my lord, the next page 311, that, my lord, the arbitrator again travels beyond what is agreed between the parties. I'll show the notification of the government of India, my lord. The notification says, my lord, whatever they construct in my land, they will have no right to it. Once, my lord, it is terminated. The arbitrator holds just the opposite without considering the same. Kindly sees, my lord, 1.0 general. This land license agreement for the private siding shall be governed by Railway Board Circular number 96 such and such dated 23rd 10 2000 1997. এই নোটিফিকেশনটা পার করো। And, my lord, I want to show the notification to my lord, that, my lord, it says that whatever is built belongs to me once I terminate. There cannot be any claim in respect of that. My lord, kindly apropos keeping this side by side, kindly opens, my lord, once page 456, my lord. It's in volume
4.
Volume, my lord, 4. Just, my lord, for the sake of, my lord, showing that, my lord, how the arbitrator has traveled beyond the scope, my lord.
Yes.
My lord, kindly takes this notification 23/10/1997.
Yes.
My lord, first one, railway will allow investment by private parties in development of goods sheds sidings. Railway would, however, reserve the right to close the goods shed siding if the same belongs financially or operationally unsustainable at some stage by giving notice of 90 days. So termination is in my hands. Railway will allow investment by private parties at stations as per railway's operational convenience on receipt of an application from the parties. Now, my lord, kindly skips, my lord, 3 because that's not required. Kindly, my lord, comes to 4. The facility so created would be used not only by the parties who have financed them, but also by others, and assets so created would belong to the Indian Railways and would be maintained and used as any other railway assets with absolute authority. The investor would not be eligible for any return, concession in lieu of such use of these assets by the railways or other rail users. The investors will not qualify for any preferential treatment in the matter of utilization of these resources. Land may be licensed as per extent rules for construction of temporary storage sheds to investing parties, subject to the stipulation that the land would be licensed only when the goods are to be transported by rail. So, my lord, the right to terminate is with me. The right to retention, my lord, post termination is also with me. And it does not belong to him exclusively even during the tenure of the period, my lord, of the agreement. Now, my lord, this is, my lord, completely, my lord, recorded in the agreement by, my lord, clause 1.0 small a. This is binding, my lord, on the parties at page 311 because this agreement is governed by the same circular. Now, my lord, as I said, by the time the agreement was entered into, they had even taken more land because, my lord, the others had left. That lordship will get from 2.0, 2.1, my lord, the next clause. The railway land required for laying the siding will be licensed to the licensee the administration hereby permits the license.
Where are you reading this?
My lord, 2.0, the next clause at page 311, my lord. I showed 1.0.
This one, yes.
Yes, my lord. Now, my lord, kindly sees 2.0, the railway land required for laying the siding will be licensed to the licensee. Administration hereby permits the license from, kindly mark this, my lord, 16/12/2007. So, my lord, the agreement agreed upon by the parties, my lord.
Which is the corresponding page?
My lord, 311. My lord, this is volume, my lord, 3.
The circular is where?
Yes, my lord.
So this letter of 30th.
Oh, the circular is at page, my lord, 456. That is volume, my lord, volume 4.
So that's the first circular. That's the 23rd of.
Yes, I am only showing one. I did not trouble my lord with the others, because that is enough to show that the, my lord, tribunal could not have given the compensation or, my lord, the damages to them, because it belongs to me. Now, my lord, kindly sees, my lord, the date which the parties agree in terms of the agreement itself. That's, my lord, at 311, 2.1. That's, my lord, the administration hereby permits the license. Lord, you will kindly mark it 16/12/2007. So, my lord, my license fee starts from 2007 till the date I terminate, and therefore, after that, I'm entitled to damages on the said land for, my lord, illegally occupying the same. Now, my lord, dated to occupy the area also kindly sees, my lord, 17.0241 acres.
Yes.
So, my lord, the agreement signed by both the parties records in no uncertain terms that, my lord, 2007 he's got possession of 17.241 acres. Now, my lord, I will show lordship, my lord, again I'll reiterate, my lord. Now, my lord, I will show, my lord, that the arbitrator says this is also wrongful. That, my lord, land was not given to them. He was not in possession of the land to the extent that he was supposed to. He's not entitled to pay me the license fees. But I don't think, my lord, when the agreement, my lord, records it, the arbitrator has anything further to say. This is agreed upon by the parties. Now, my lord, kindly takes thereafter one more clause here in this page, 2.2. The licensee will have to pay for land license fee at the rate of 6% per annum of the market value of the land. So, my lord, today I am also supposed to get, my lord, compensation at the rate of 6% per annum on the market value plus interest on that amount for wrongfully, my lord, holding on to the land of the land at such rates as may be revised from time to time. The licensee will be revised every year with a notional increase in the land value of 7% per annum, or at such rate as may be revised from time to time over the previous year's market value of land to arrive at the land value of the current year. This also, my lord, I will show that they have disputed. Arbitrator has held that that is correct. My lord, the clauses cannot be, my lord, adjudicated upon to show that, my lord, the agreement cannot be rewritten by the arbitrator. That's not permissible under, my lord, the Contract Act or the Arbitration, my lord, Act. He has agreed that this would be the rate, and, my lord, it would increase by a certain rate every year upon the market value. Now, my lord, the arbitrator holds that this increase is also, my lord, not correct, because he complains of extra money being taken from him. Now, my lord, kindly straight away from there, kindly comes to page 320, my lord, part of the agreement, annexure 1. This is, my lord, the agreed rate as on 2012, my lord. Kindly sees, my lord, Conservancy says the license fee shall include conservancy charges for the period from 1/4/2012 to 3/6/2012 at the rate of 84 rupees per month, as for the period from 1/7/2012 to 31st/3/2013, such and such per month, this is liable to be revised. And over just top of that, my lord, you will find extent of land is 17.0241 acres. Date of occupation signed by him at the bottom is 6/12/2007. Admitted by them. And then the rate, my lord, has been given. This even is challenged by them before the arbitrator, and the arbitrator holds that, my lord, they are entitled to, my lord, not to give the amount in terms of this agreement also. This is also was challenged before the arbitrator. Now kindly, my lord, sees, my lord,
এখানে ওরা বলছে আমরা সব জায়গা দিয়ে দিয়েছি, আমরা কোনো এটা ডিসপিউট করে জায়গা দিই না, আমরা জায়গা দিয়ে দিয়েছি। এখানে বলছে সিনারিও চেঞ্জ, ওই গভর্নমেন্ট নোটিফিকেশন সিনারিও চেঞ্জ হবে, তো ওরা বলছে যে
now, my lord, করে দাও। Now, my lord, kindly sees, my lord, one last document before I take my lord to the award is that, as I said, the government of India, my lord, came up with a notification that interstate coal transportation will not be allowed. My lord, so this was a, my lord, policy making of the government of India. The parties, my lord, does not have any right to it. And my lord, the parties to an agreement, my lord, never even thought of this, my lord, could happen. And neither this was one of the, my lord, eventualities under the agreement. Now, my lord, they all of a my lord, certain, my lord, in at page 321, lord, she will find a letter written by them on 13th of October 2014 for, my lord, the agreement to be modified. Kindly sees, my lord, and this is held to be correct by the arbitrator. Utilization of private siding by electro-steel castings at Durga Chowk station on railway land. Details of approval again given, my lord, in principle approval 2006, DPR approval 14/11/2006, engineering plan approval 25/7/2007, land licensing agreement 22/1/2013. And after this letter of admission from them, the arbitrator holds that the commissioning could not be done because of us. After this admission, now, my lord, kindly sees what is there, my lord, scheme of this letter. Present siding status: the construction of 2 loading unloading lines with rail level platforms at the station yard, as also overhead electrification and signaling and interlocking work has been completed. The siding is now in the process of commissioning. So, my lord, kindly sees from 2006 till 2014, they themselves admit that they have not commissioned it as yet. I don't need evidence for that. This documents prove for itself, their evidence only, their documents itself. Till 2014, they have not commissioned it. Then, my lord, facilities provided in the siding are, then it is detailed. Then, my lord, kindly sees what he claims. The siding was envisaged for inward movement of iron ore and coal and outward movement of coke and sponge iron. My lord, as I read out to my lord from the earlier, my lord, letters. In view of the change in business scenario due to drastic increase in freight of iron ore, change of iron ore mining rules in the state, restriction on transportation iron ore for loading from one state to another, utilization of this siding is expected to entail additional handling costs to the tune of rupees 250 metric tons, and therefore discourages the use of siding for handling traffic. Well, this is his problem. This is his problem. I cannot be saddled, my lord, anything with respect to any change in policy of the government of India. Neither parties foresee, my lord, certain situations which may arrive, my lord, in the future. And, my lord, this modification he cannot ask for as a matter of right. If I, my lord, disregard it, that's the end of the story. Because the right is with me, my lord, whether, my lord, I'll accept it or not. Because, my lord, there cannot be any forceful modification of a contract made if the other party does not agree. But the arbitrator holds otherwise, saying that, my lord, I have changed the agreement. And therefore, 73 crores as compensation has to be paid. Just, my lord, one page of printout given, 73 crores compensation has to be given from public money. And my lord, categorically I have replied to it denying that I will not be able to make such modification because that's not permissible. Kindly seize, my lord, page 429 of volume, my lord, 4.
আর 2-3টে চিঠি লিখে দরকার আছে, ভেরি ইম্পর্টেন্ট।
কি আর কি আছে বলো?
কমিশন করতে বলেছে, ওরা করেনি, ডিমান্ড করেছে ওরা ওটা।
My lord, this is the letter I give a reply. Kindly seize, my lord, 10/11/2014. In connection to the letter referred above, my lord, kindly seize the reference of the letter which I read out just now is there, dated 13th October 2014, just at the top of it, my lord. This is the reply to that letter. The siding has been approved in terms of the Electro Steel Casting Limited. Change of ownership of the siding going in for a joint venture with another firm is not permitted at this stage. This is what they had suggested. Fresh application and approval will be required. Moreover, the siding is on railway land and private siding on railway land is not permitted at present. So, my lord, the policies have now changed. I could have given him then, but I couldn't have been able to give it to him now. And, my lord, no joint venture was allowed under our, my lord, rules. Transfer of the siding to a container train operator is also not possible. However, co-user of only one company is permitted as per the extent rules railway board's letter such and such circular dated 23/4/2012 and my lord finance ministry circular dated my lord such and such. So you can propose for only one company, which may be a CTO or a company handling bulk traffic, as a co-user of your siding. As such, there is no provision that railway will take over the siding against compensation. Since the siding is on railway land, railway may take over without compensation. So that's, my lord, because of the 1997, my lord, notification which I read out, that, my lord, if I have to take over post termination, I'm not supposed to pay you any compensation. I'm going to take over the, my lord, entire project, my lord, of yours without paying a single compensation to you. And, my lord, I cannot, my lord, modify the agreement because the policies have changed. Moreover, my lord, that's not permissible under the, my lord, rules of the railways. Now, this is held contrary against me, saying that I have breached the agreement by, my lord, not modifying the agreement with him since he, my lord, faced certain obstacles. But, my lord, that was never the understanding between the parties, as I showed from, my lord, from the agreement and the various correspondences. My lord, there was nothing before the arbitrator to show that, my lord, it entitled them to this modification, and since I have not given that, my lord, amounts to a breach.
329 কমিশন করতে বলেছে ওরা করেনি।
Now, my lord, that kindly comes to page 329, where I, my lord, ask him to commission the project, my lord, to commission the project, my lord, which was to be done by them. 329.
24 ও sorry, sorry, sorry.
It starts at, my lord, 324.
না, আমি ভুল বলেছি, 324, thank you. ওটা আপনার কন্ট্যাক্ট।
My lord, kindly sees the date. It's on 8th of June 2015, page 324.
কমিশন করি। আজ কোন কমিশন
রিপ্লাই দিয়েছিল
ফটো রিপোর্টে দিন।
এখানে কম্পেনসেশন চাইছে
না না বিজনেস সিনারিও চেঞ্জ হয়েছে তো।
দেখাতে হবে। My lord, this is very important because, my lord, it is an established fact. They are also saying that it wasn't commissioned, as I showed their letter. As way back in 2015 also, my lord, they have not commissioned the project. Now, my lord, kindly takes this letter, which is written on 8/6/2015 at page 324, my lord. Please refer to the above quoted letter. The request for granting 6 months' time for deferred payment of land licensing fees and commissioning of the siding was examined, and it was clearly spelt out that the deferred payment of land licensing fees could not be agreed to, as the land has already handed over to Messrs. ECL, that's, my lord, them, and siding has been constructed on the said land. The same has not yet been deposited. So money was not coming. They were not paying the land licensing fees even. Further, it was also informed to you that further delay in commissioning the siding after the time period of 6 months as required by you would adversely affect the commissioning of the Durga Chowk panel and doubling of Bashulia Sutahati Junction cabin to Durga Chowk station. As a result, there would be no option for the railways but to delink the siding commissioning from the present interlocking plan, keeping a future provision with additional cost to be borne by Electro Steel Casting Limited. It is requested to take necessary steps for commissioning of the siding within 1/8/2015. So, my lord, admittedly, it was not done till the date that we had requested them even in 2015. And to deposit due land licensing fees, failing which the railway authority will have no option left but to process for taking over the siding and to convert it into a public siding. So, my lord, I had requested him to commission. If not, I had to, my lord, terminate and take over the land. But arbitrator holds that, my lord, I have stopped him from commissioning. This was replied by them, my lord, at page, my lord, 225, wherein, my lord, they come up with various 325, the next page. My lord, kindly sees, my lord, 5/8/2015, their reply at page 325. Important, Kana? Further to correspondence as referred above on the caption subject, we would make following submission. We submitted a proposal to build private siding on railways land at Durgachar or obtained principal approval from railways at 6/2/2006, considering rapid anticipation growth in our mineral-based industry at Haldia in future. DPR was approved. So, my lord, thereafter the dates are again reiterated by them. While some small work is pending for commissioning. So, my lord, there is an admission by them that they have not commissioned from their end. While some small work is pending for commissioning of the siding, complete adverse change in mineral-based and steel industry during the last 3 years and following conditions from railways involving huge cost implications forced us to rethink on this project, wherein our to-date investment exceeds rupees 35 crores. Whatever be their investment, I'm not interested in that. This agreement was not, my lord, what is going to invest there. My agreement was that I'm going to give them the land, I'm going to get the freight out of the rakes that he has promised me, and, my lord, the land licensing fees. And, my lord, if there is a policy decision change of the Union of India, even I'm not bothered with that, my lord, because that does not bind the agreement between the parties. Kindly sees, my lord. In view of the aforesaid circumstances, we do not see a viable utilization of this siding in foreseeable future. Our company is passing through a difficult financial and business challenge at this time. We have been a faithful customer of Southeastern Railways during the last few decades. We therefore would like to request, so it's a request from their end, your kind consideration as follows. Southeastern Railway may evaluate net investment in this railway asset by ECL and refund us the amount by, say, 20% freight rebate adjustment over next 5 years or so, and take over this siding for railway's own usage. Southeastern Railway management would freeze land licensing fees till business scenario improves. 2 years to enable ECL come with revenue generation usage for this siding. So, my lord, this letter clearly shows that this is a request made by them. This cannot be, my lord, a ground as held by the arbitrator that this is what I am supposed to do, and if I don't, then that's a breach. And moreover, my lord, kindly sees, my lord, they also accept that.
How much time will you take?
My lord, I would take one more letter and then show the award, my lord. I can come back, my lord, any day lordship pleases, my lord.
Let's finish the letter at least. So
Yes, yes, my lord. May I just, my lord, therefore, my lord, before I go away from this document, my lord, two things are very important. One is that, my lord, they themselves admit that they have not acted in terms of the agreement. Secondly, my lord, they make a request. Now, my lord, this cannot be connoted, my lord, that, my lord, breach has been committed by us because I have not accepted the request. And that's exactly what the arbitrator has held, that I have committed a breach by not modifying the agreement as they requested to me. If I would have accepted the request and then, my lord, otherwise acted, I would have understood I have committed a breach. Yes. But when I have never accepted the request, question of committing a breach, my lord, thereafter does not arise. Now, my lord, kindly sees apropos this, the next letter itself, which, my lord, is at 326, 28/4/2017.
ল্যান্ডটা চেক ল্যান্ড পেনি
Whereby, my lord, I understand that they cannot complete the project. I ask for return of the land, my lord. So this is the, my lord, letter at 28/4/2017.
আমরা টার্মিনেট করলাম তারপর
Yes.
Please refer to your letter quoted above, wherein you have expressed your inability to take up the balance siding works. You have also requested that Southeastern Railway may either take over the siding and refund the net investment after deducting all outstanding by way of freight rebate, or freeze the land licensing dues till the business scenario improves. Ultimately, none of your requests can be considered. So in no uncertain terms, I have, my lord, rejected all his requests. Ultimately, none of your requests can be considered within framework of the rules, guidelines issued by the Railway Board. In this regard, it may be mentioned here that since 2013, your approval of SIP, you did not take any viable initiative to complete your proposed siding. In response to your letter dated such and such and such and such, Railway Administrator had granted 6 months time. So I gave him an extension, my lord, till 1/8/2015 to take effective steps for commissioning the siding and to clear the outstanding dues. However, no action was taken. Again, a reminder was issued on September 2015 with a direction to clear the outstanding dues and to complete the construction of the siding works, failing which Railway Administration will withdraw all permission given earlier, including vacation of the railway land. A considerable time has already passed. No action has been taken from your end to commission the private siding. In view of the above, the competent authority hereby withdraw all permissions given earlier and has decided to foreclose your proposed siding at Durga Chowk. This is without prejudice to the right of the railway authorities to forfeit the, my lord, charges already paid. In connection, it is stated that railway authority reserves the right to recover the outstanding dues and, my lord, licensing fees and hand over the vacated railway land in your possession to the appropriate divisional authority. So I terminate and I say, my lord, that you give back the land to us.
ওটা ডিমান্ড নোটিশ পাঠায় তারপরে
Now, after this, what happens, my lord? They send a demand notice to us, contrary to the entire, my lord, documents and, my lord, the agreement. And, my lord, thereafter reference was made to the arbitration. So, my lord, I can come back on the next day and then start with the arbitrator's award, my lord.
একদম পার্ট বাই পার্ট আমাদের
When do you want now?
But I can come back on Friday morning, but I believe, my lord, Mr. Sen has some problem on Friday, my lord.
Mukherjee is there. No, next week, not that.
Next week, Mr. Mukherjee?
I can come back then on Monday, my lord, if your lordship wants, my lord.
Have it?
Yes, yes.
Heard Mr. Banerjee. List for further argument on the 17th.
17 তো রাত্রিরে যাচ্ছি আমি বম্বে।
Clear?
না, বম্বে থেকে 18 তারিখ।
সুশীল তোমার
17th.
Yes,
Basic.
Your Lordship,
Mention in
that's
the morning, sir.
long time. The appellate side.
I know, mention in the morning. Yes, Mr. I was supposed to.
My lord, only one thing, my lord. Before my learned friend, on behalf of the municipality, submits his case. In a nutshell, my lord, lordship remembers everything, but still I will, lordship, take your lordship to the order which was passed by Honorable Justice Bhattacharya, that is at page 100, and which was page 186. Page 186, my lord. Kindly, this has. May I place this order, my lord?
Yes.
সৌগত ভট্টাচার্য অর্ডারটা আগে প্লেস করে দিন আপনি
That order is modified. কেন বলছিস?
মানে lordship
If
will.
this order has been modified, then
No, modified means, my lord, on the basis of this order, director of local bodies
right.
was asked to consider the case of the petitioner for
All right,
grant of
all right.
petition
Tell me.
benefit. Now, there is a circular.
Read it, sir. You read the order. What are you relying
Yes,
upon?
page
You talk.
186. Page 186. একটু আস্তে আমি কথা বলছি। Petitioners are the resident medical officers of Domdom municipality who were appointed on different dates by the concerned authorities. It has been submitted by the learned advocate representing the petitioners that petitioners have retired in the meantime, barring few who are serving on extension. Petitioners pray for settlement of pension upon granting of post facto approval. In course of hearing, an order dated 6 February 2023 issued by the Additional Secretary to the Government of West Bengal Department of Urban Development and Municipal Affairs branch has been placed before this court, whereby previous circular applicable in the field was amended by inserting clause 2A. In addition thereto, reliance has been placed on behalf of the petitioners on the order dated 23rd March 2022 passed by this court on WPA such and such Shoktilal Chaudhary versus the chairman of the municipality, and the judgment of the Honorable Division Bench dated 13th October 2023, whereby the order dated 23rd March 2022 passed by this court in the petition of Dr. Shoktilal Chaudhary has been affirmed. It has been further submitted on behalf of the petitioners that the case of the present petitioner is covered by the order dated 23rd March 2022 passed by this court in Dr. Shoktilal Chaudhary Supra, and the judgment of the Honorable Division Bench dated 13th October 2023. Petitioner pray for similar order in consideration of the order passed by this court previously as relied on during course of hearing. Domdom municipality is not represented today. However, state respondents are represented by Mr. Basu Mollik, learned advocate. Having considered the submissions made on behalf of the parties and in consideration of the order dated 23rd March 2022, it appears that this court decided the issue in favor of the petitioner in WPA 4259 of 2016 in the light of the relevant circulars available at the material point of time and relevant statutory provisions when the circular letter dated 6 February 2023 was not existing. Now, in view of the issuance of circular letter dated 6 February 2023, the situation has been substantially changed due to insertion of clause 2A in the said circular. For better understanding of the issue, clause 2A of the circular dated 6 February 2023 is quoted below. 2A, in the last para of the words, to authorize the Director of Local Bodies West Bengal to issue orders according post facto approval of the appointments promotion made by the municipalities against the sanctioned vacancies holding erstwhile scale of 380,910 since revised to 4,000, 8,850 and below within the aforesaid period on case-to-case basis after due examination and inquiry. The words to declare that the initial appointment promotion in respect of all the officers and employees not included in the subsection 1 of section 54 of the West Bengal Municipal Act 1993 made by the municipalities against the sanctioned vacancies between the period 14th day of July 1994 to the 30th day of September 2023 shall be deemed to have been done as per extant provisions of West Bengal Municipal Act 1993 and has ratification of the state government shall be substituted. Having considered the aforesaid situation, this court finds it apt to direct the Director of Local Bodies, being the respondent number 6, to decide the issue.
All right, it will be decided in terms of the circular.
No, they have not, my lord. The plea they have taken is that they have filed a review application against the order of the division bench, which was passed, and that review application was pending. So that was the plea which was taken. For that reason, Director Local Bodies did not consider all these aspects. Now, my lord, the circular which has been issued has clearly stated in no uncertain term that the doctors who are appointed against a sanction vacancy, because Shaktilal Chaudhury's matter has been complied, order has been complied ultimately, so state has accepted the fact that the municipality had the power of creating the post in respect of the 1% of the total sanctioned post and can offer appointment, and that has been done, and that has been endorsed by the state government by complying Shaktilal Chaudhury's order. And my lord, after that, the review application were dismissed. That was all pensionary benefits were given, and that matter only relates with so far as the West Bengal Municipal Act is concerned. My lord, I have made a chart, my lord, for your lordship's convenience. The appointments, my lord, so far as these petitioners are concerned, my lord, in this particular matter, my lord, so far as the state's plea is concerned, if your lordship kindly can come to the paragraph number 3 in the report, they say the report of the state government is very clear. Kindly come to para 3. They have said that it may be stated,
Just a minute.
report of the state, my lord, respondent number 2, paragraph 3. It may be stated that the case of the petitioner Dr. Ashit Ranjan Kundu, the petitioner hearing, is similarly situated as in MAT 890 of 2022, and the decision passed by the division bench of this court on 13th of October 2023 is applicable to the petitioner. So this is the stand of this, so far as the writ petitioner number 1 is concerned. And same stand has been taken, my lord, in order to cut short the precious judicial time, my lord, same stand has been taken in respect of WPA 16837 of 2024, which is appearing at item number 7. Same thing,
In your chart, which one?
serial 7. Next page. Priyodorshi Sarkar, WPA 16837 of 2024. My lord, state has stated that post validly created para 5 and 6. And municipality has said it's partly applicable because of the reason Shaktilal Chaudhury has already retired from the service, and these two incumbents, my lord, item number 1 and 7, they are still in service, and their retirement age is also have stated. One is of 2036 and another is 2031, and both of them have been appointed under substantive capacity. So this is so far as the petition number 1 and 7 are concerned, my lord, is concerned. And also, lordship will find from the municipal affidavit of the municipality that they have also stated that the posts were validly created. Kindly come to page 7 of the municipality's report. Respondent number 3 and 4. Lordship has found para 8 and para 9.
Yes.
On verification, lordship, kindly see these 3 names are appearing.
Shaktilal
Shaktilal Chaudhury complied. Ashit Ranjan Kundu, that is the petitioner number 1, and Dr. Priyodorshi Sarkar, petitioner number 7. These 3 persons, my lord, so far as one is concerned, has been complied, and these 2 are similarly placed with them. And state respondents have also accepted that in their respective affidavit.
All right. All right. So 1 and
7 covered.
next.
Next, number 2.
No dispute.
Yes.
No, no dispute. 1 and 7.
Yes, yes. I just press it. Why? That reason also given by me.
But
I did not dispute. He there.
All right.
That I give. I just.
my lord, number 2 is matter Rafiqul Hasan.
Paragraph number 4 of my report.
Read it out.
The Dhamra municipality in their affidavit has proclaimed that the period of stretching from 198, 31st August 22, only three. Who did not follow and they were appointed in exercise of power section 53(4) of the said act. They are Dr. Shaktilal Chaudhary, Dr. Ashit Ranjan Kundu, and Dr. Priyadarshi Sarkar. These three.
That's what he's saying.
These three persons applicable.
He's saying. That's what he's saying.
Yes.
That's exactly what he's also said.
Now, my lord, so far as item number 2 is concerned, Dr. Rafiqul Hasan,
Yes.
my lord, he was appointed when Bengal Municipal Act was in force. His appointment was also substantive and he has retired in the year 2016. The contention of the state that he has been appointed against an unsanctioned post, whereas, my lord, municipality's content is this: he has been validly appointed as per the power which was there with the chairman to create post and to confer upon, which does not require the approval of the state. And so far as the Rafiqul Hasan's case is concerned, division bench judgment which I will be relying, but prior to that, my lord, coordinate bench also has passed a similar order in respect of Bengal Municipal Act, which I have annexed at page 86. Lordship, kindly come to page 86. And this has also been complied. The matter was not taken before the division bench also.
Yes.
My lord, may I read? The sole grievance of the petitioner in this writ petition is non-disbursement of retirement benefits admissible to her deceased husband even after his superannuation till date. Admittedly, the husband of the petitioner was a resident medical officer in Domdom Municipal Specialized Hospital with effect from 2nd May 1983. The service of the husband was approved with effect from 11 September 1984, indicating he would be entitled to all admissible allowances and benefits of Provident Fund contribution with effect from 5th November 1983. The husband of the petitioner superannuated from his post on 31st of May 2014 after serving nearly 31 years with a high expectation of getting those allowances and benefits admissible to such services. It is unfortunate that the husband of the petitioner was running from pillar to post to have his legal dues paid to him, but having failed in all such attempt, it is alleged that he has committed suicide. Now he has been substituted by his wife. The wife has now taken up the responsibility and has approached this court for a direction upon the respondents so that allowances and benefits which are admissible to the deceased husband may be given to her. The municipality says that they have forwarded all relevant documents to the Director of Local Bodies, the respondent number 5 herein, and file is stuck up there. Though feebly it is submitted on behalf of the municipality that the employment of the husband was not in concurrence with the state approval and therefore no benefits can be extended to such employee. My attention is drawn to a division bench judgment rendered in case of Chairman Domdom Municipality and others versus Dr. Devranjan Bishwas and another, MAT 707 of 2007, decided on 30th of January.
They have complied with it?
Yes. They have complied with this order without preferring any appeal and relying upon the division bench judgment, my lord. I have also annexed that also. The division bench expressly observed therein that the confirmation and approval to such service was given at a relevant point of time when Bengal Municipal Act was in vogue. Section 66(3), subsection 3 of the Act of 1932 does not make any distinction which sought to be made by the chairman of the said municipality. In the backdrop of the above, it is observed, upon perusal of the aforementioned provisions as contained in section 66 of the Bengal Municipal Act 1932, we are of the view that at the relevant point of time when the respondent number 1 was appointed, the commissioners of municipality could have appointed the writ petitioner respondent number 1. It is nobody's case that the post on which he was appointed was more than 1% of the total number of posts as contemplated in the first proviso to section 66 above. It is therefore clear from the observation of the division bench that the relevant point of time, section 66 of the Act of 1932 empowers the municipality to appoint medical officer provided the conditions laid down therein are fulfilled. Since the instant case stands in parity with the facts of the said case, this court therefore has no hesitation to hold that the ratio laid down by the division bench equally applies to the petitioner hearing. the chairman of the Damdam municipality is directed to forward all relevant papers, if not already forwarded, to the respondent number 5 within 2 weeks from date. The respondent number 5 is directed to release all admissible dues of the petitioner's deceased husband within 3 weeks from the date of receiving the relevant records from the chairman of the said municipality or from the date of communication of this order, whichever is later. It goes without saying that all
All right,
legitimate dues
sir.
of the petitioner's deceased husband would be paid.
All right. Yes.
Yes,
Yes. What else?
yes. Well, so far as the state's contention is concerned, state has said at paragraph 11 of the report that it is an unsanctioned post. So no approval was taken from their end. So appointment is not as per the rules. And so far as the municipalities are concerned, they have said, my lord, at para 7 and 8, that they could have been appointed.
All right.
They could have been appointed. So I am at, as because this matter is covered under the Bengal Municipal Act, my lord, the judgment of the division bench in Debranjan Bishwas's case and Bornali Malaka's case squarely covers the field. I have stated that also. Well, so far as this is my respectful, so far as item number 2 is concerned. না 3 আমি কি পরপরটা বলবো নাকি?
Yes, yes, go ahead.
Item number 3, my lord, so far as Bidhan Chandra Mondol is concerned, this case is also falls under the Bengal Municipal Act. Here also, my lord, I will be reiterating my submission that Debranjan Bishwas's case and Bornali Manaka's case squarely covers this field. So far as the state's contention is concerned, they have again said that it's an unsanctioned post, no approval was taken from their end. And from the municipality's point of view, paragraph 8 and 9, they have said this is a fit case. These are the eligible candidates who have been appointed as per the then rules which was prevalent at that relevant point of time. So, my lord, I will be praying for similar relief so far as the division bench passed in 707 Debranjan Bishwas case and Bornali Malaka's case in the present proceedings. This is so far as the item number 3 is concerned. Well, item number 4 is Purnima Bishwas's case, my lord. This also, it is the fact that, my lord, her husband was working as a residential medical officer, but after retirement, my lord, Dr. Nitya Gopal Bishwas committed suicide. It's the same thing like Bornali Malakar, because his pension benefits were not given, released. So his wife is substituted, and accordingly, my lord, same state contention of the state that it is unsanctioned, and municipality has also reiterated their stance with the state government that at that material point of time, there were 2 sanctioned posts, but 4 persons were appointed. So 2 persons could not have been appointed, but they have appointed, but appointed under a substantive capacity. If your lordship sees the service book, my lord will find it's a substantive post. So lordship is well aware of the judgments. I have come up here with the relevant judgments that substantive post, my lord, if it is appointed, it's against a permanent vacancy. It's for an indefinite period. And it is also absorbed after confirmation or completion of probation. So this case also, my lord, if your lordship allows me to place those judgment, I can place those judgment on substantive capacity.
No need, no need. No need, sir, no need.
So this is so far as here also, my lord, I will be relying upon division bench judgment and Bornali Malaka's judgment. Then Omlan Kanti Mojumdar, my lord. His case is coming under West Bengal Municipal Act. His appointment is also substantive appointment, and he is still in service. He will be retiring in the year 2031. The contention of the state is same. It's an unsanctioned post. And municipality has also said that they have appointed beyond the sanctioned post, but it's a substantive appointment. It is covered under the Debranjan Bishwas's case and Bornali Malakar's case. And all these names, lordship will find in the recent division bench judgment, lordship I have shown for your lordship's satisfaction, if your lordship ask me, I can again show that these are the names of the petitioners where repeated occasion were sent to the office of the director of local bodies to take action, but director of local bodies has not taken any action. Rather, when their names were appearing, when the municipality filed their affidavit before the division bench, in Shoktilal Chaudhury's case, state was asked to give a reply whether they have any objection to their names or not. State refrained from giving any opposition to the names which were suggested or which was forwarded to them by the municipalities. These are all have stated here, my. Shall I show the relevant paragraph?
No, no need, no need.
Because their names are reflecting in the division bench of at page 117 onwards.
Got it. 7 you have already covered. 8.
Yeah.
8.
8. Well, no, probably I have 6.
6. Yes, 6.
6, my lord, it's also under Bengal Municipal Act.
Yes.
Appointment is substantive. He has already retired from the service after 30 years of service, my lord, on 31st of January 2025. State's contention, again, unsanctioned post, no approval was taken. Municipality has said it's a valid appointment as per the relevant provisions. I am governed by the order of the division bench and also order of the single bench. Both of them have been complied with. So far as item number 8 is concerned, my lord, it's covered under West Bengal Municipal Act. He is still in service. His retirement age is in 2033.
Yes.
Contention of the respondent is same. It's unsanctioned post, and they have also taken another plea that records are missing. Records are missing, and no prior approval has been taken. But the contention of the municipality appointment is a valid appointment as per paragraph 8 and 9. I am covered by the division bench of MAT 890 of 2022, which has been complied and implemented. Now, Amitesh Sarkar's case, my lord.
Item number 9.
9. I'm bowling it. It's coming under West Bengal Municipal Act, my lord.
Yes.
It's also a substantive appointment. Retirement on 31st of July 2022. State's contention, unsanctioned post, no approval was taken. Municipal contention at paragraph 8, eligible for appointment. Municipality has said, I am covered by MAT 890 of 2022.
Subject to your lordship's approval in item number 9, I have certain objections to raise. Should I make the submission right now or after completion of?
Let him complete.
Great.
So far as item number
You can make your objections, whatever objection you want to make.
My lord, we have filed our opposition. My lord, this matter, my lord, item number 9, Amitesh Sarkar, lordship kindly takes up the writ petition, my lord, once.
Yes.
My lord, page 41A of the writ petition. That is the letter of engagement of the writ petition. My lord, you are hereby appointed as residential medical officer as on substantive basis in the postings which has been officiating since October 1981 as per resolution of the ordinary meeting of the commissions of the Damdam municipality held on such and such date. Your initial, my lord, I'll be giving stress on this. Your initial basic pay would be rupees such and such in the scale of pay of rupees such and such. And this shall be in effect from 1/7/1991. Now, my lord, pausing here for a moment, in this case, the writ petitioner was appointed on 17/18th of June 1991. Now, the decision my learned friend is relying on, or the honorable division bench has, my lord, that is in respect of MAC 704 of 2000 70 in respect of an appointment that is given in year 1990. Pausing here for a moment, I will be inviting your
2007.
I will be inviting your lordship's attention to section 66 of the Bengal Bill. Minor 1932. Minor times. Minor 66. Lordship proviso. I am reading. Immediately I am handing over. Well, the proviso says section 66.
You should have given me extract.
Xerox.
What is it? 1% one?
No, minor kindly says proviso.
Yes.
Yes. Minor provided further that no post carrying a monthly salary of more than 1,000 rupees or a salary rising by periodical increments to more than 1,000 rupees shall be created without the sanction of the state government. Well, pausing here for a moment, well, again, I'll be drawing your lordship's attention to the letter of appointment of the writ petitioner in this case. Well, admittedly, his salary has been fixed at the rate of rupees 2,200 per month. This under this proviso 66, this proviso clause, well, at my humble submission, subject to correction, the concerned municipality ought to have taken permission from the state government. This is in respect of an appointment made in the year 1991, and this 1993 Act has no manner of application. This is under 1932 Act, section 66. Appointment made in the year 1991. So, my lord, this proviso clause, under this proviso clause, the concerned municipality ought to have taken prior permission from the state government. I have, my lord, in my report, I have also specified this. Now, my lord, pausing here for a moment, my lord, my alternative argument will be in the event that if but if you continue, your lordship decides in favor of the writ petition, that writ petition and the entitlement to pension and such manner pensionary benefits would have been paid to the but this is my alternative argument. Lordship kindly accept this West Bengal Municipal Employees Death Cum Retirement Benefit Rules 2000. Under this particular rules, read with the 1993 Act, Rule 31, my lord, I am relying upon. It is the sole responsibility of the concerned municipality. The state government, my lord, they are no way, my lord, should be held liable for payment of the pensionary benefit of a municipal employee. My lord, kindly see Rule 31. Rule 31. Even my learned friend also annexed this in his writ petition.
237.
Minor. This is the responsibility and liability and or onus of the municipality. So, minor, this is my full submission that sanction is required under the old Act at Proviso 66. Even if your lordship and give the benefit of pensionary benefit, the state government should not be held liable and responsible under this particular Act. Well, this is my question.
Yes.
My lord, will immediately come to page 77. because I was given an appointment in the capacity of residential medical officer. That is an officer which is not coming within the list of those officers where the approval of the state government was required. Kindly come to page 77 for once. This has been dealt. My lord, yes. Second paragraph, my lord. Learned counsel for the writ petitioner responded now has drawn our attention to the provisions of section 66 of the said Municipal Act 1932. It would therefore be apposite to take note of the said provision here at this stage itself, because same clearly gave a right upon the commissioner of the municipality not only to determine what officers and employees were necessary for the municipality, but also gave them the right to create posts of such officers, employees, and to fix their salaries and allowances. The post of officers to be created by the commissioners under subsection 1, section 66 included the post of a medical officer, and section 61(1) read with section 66(3) of the Bengal Municipal Act 1932 read as under. Section 66 appointment of officers and employees. The commissioners at a meeting may, subject to the provision of this act and the rules made thereunder from time to time, determine what officers and the employees of the commissioners are necessary for the municipality, create posts of such officers and employees, and fix the salaries and allowances to be paid and granted such officers and employees, provided that no post of no officer of employee shall be created without prior sanction of the honorable government if the number of posts to be so created in a year for a municipality is more than 1% of the total number of the posts of officers and employees that existed in the year immediately preceding. Provided further that no post carrying a monthly salary of more than 1,000 rupees or a salary rising by periodically particulars to more than 1,000 rupees shall be created without sanction of the state government. The post of the officers to be created by the commissioners under subsection may include a secretary, medical officer, one or more the sanitary inspectors, superintendent of waterworks, an assessor, and officer, superintendent, and accountant, provided that every officer referred to in this subsection shall be possess such qualification as may prescribe. Upon perusal of the aforementioned provision as contained in section 66 of the Bengal Municipal Act, we are of the view that the relevant point of time when the respondent number 1 was appointed, commissioners of the municipality could have appointed the writ petitioner respondent number 1. It is nobody's case that the post on which he was appointed was more than 1%. My lord, the list is clearly stated. I was initially appointed under an officiating capacity. That is, it is appeared from the letter of appointment as shown by my learned friend, that is at page 41(1)(a). Kindly see, you are hereby appointed as residential medical officer substantive basis in the post which has been officiating since October 1981. Remember, what was my pay scale at that relevant point of time? They should have disclosed it. And they are giving me the regular pay scale from the year 1988. No, from 1991. Your initial basic pay would be 2,200 in the scale of pay of 2,200, and this shall be in effect from 1991. But I was officiating 10 years back.
All right.
So that time, my lord, the pay scale was very, very low at that material point of time. And it comes under the purview of the pay scales as prescribed in the Bengal Municipal Act. They should not consider this 1991. They should consider this from 1981 itself.
All right.
Sorry.
10.
So far as item number 10 is concerned,
Yes.
10 is left, my lord. 10.
Yes. Tell.
She has been appointed. She is a lady medical officer, my lord.
Yes.
She has been appointed in 1991 in substantive capacity.
Yes.
At present, she is on extension after retirement because government circulars and memorandums which has been made applicable has extended the service tenure for another period of 5 years. And that has been made applicable in respect of her service also. The contention of the state is same. It's an unsanctioned post. No leave, no prior approval was taken. whereas municipality has said that she has been validly appointed. Yes. Paragraph 8.
Yes,
Paragraph 8. May I paragraph?
it's all right. I got it. Yes, Mr.
Covered under 704 2007.
Got it, sir.
Division bench.
Municipality affidavit, my lord, I have not gone through, my lord.
Then a municipal affidavit today. Municipal affidavit.
So I cannot say that the municipality has said that it is a with appointment or any sanction. Now, my lord, I think
Is it? Impugned.
kind of other year. 1/9.
9th April 2024.
Yes. Another. Into an order for a challenge. But the order passed along the managing director of local board. We have published it. Nonetheless, this order was passed by the subject to or pursuant to my lord direction given by earlier board. Now, my lord, kindly come to page number 191. My lord, the last paragraph. And whereas, have you also got that?
Yes, yes.
And whereas during the course of hearing, it is learned that the petitioners are all resident medical officers, batch of 3 petitions, and then taken up the hearing. So far the order at all residential medical officer within Domdom Medical Hospital under Domdom Municipality. Out of those, 4 petitioners have already retired from service at the court. And their grievance is that they have not received retirement benefits and pension. Remaining 6 petitioners are still in service. Colored as the present petitioner, item number 10. And their appointment has not been approved by the government. Then whereas the content of the petitioners were heard all relevant available documents, then section 53(1) of the 1993 Act quoted, and then my lord, section 53(2) also quoted, then section 53(4) quoted, so for the new Act 1993 Act. Now my lord, kindly come to 190.
193.
190, the next page.
Yes,
Continuation of the order.
yes.
At the top. And whereas, as per the provisions of section 66 of the Bengal Municipal Act 90, because so far this matter is concerned, this is Mala 3/1993 appointment. So our contention is just like that matter, that it is covered under the Mala the 3/1993 Act. Now, and whereas as per the provisions of section
32 Act.
K, section 66 of the Bengal Municipal Act 1932, the commissioners at a meeting may, subject to the provisions of this act and the rules made thereunder from time to time, determine what officers and what employees of the commissioner are necessary for the municipality to create post of such officers and employees with the salaries and allowances. Then proviso mentioned, provided that no post of an officer or employee shall be created without the prior sanction of the state government. If the number of posts so created here for a municipality is more than 1% of the total number of post of officers and employees as existed in the year immediately preceding. Then the second proviso also mentioned, provided further that no post carrying a monthly salary of more than 1,000 rupees or a salary rising by periodical increment to more than 1,000 rupees shall be created without the sanction of the state government. And whereas medical officer and resident medical officers are unanimous and carry the same scale of pay as memo number such and such of 24 April 82 of the government of West Bengal. And whereas the monthly salary of medical officer, resident medical officer is more than 1,000 rupees, hit by the provision. So it's salary rising by periodical increments also. And whereas municipality is not empowered by existing rules and regulations to create the post of medical officer without sanction of the state government. So far, pre-1992, so far those who are governed by the 1932 Act, my lord, by this order, it has been dealt with in this way, that they are not, my lord, entitled to any retirement benefit because the post was not sanctioned, no prior approval, so no question of post approval also. And then, my lord, also an issue was raised with regard to the, my lord, the applicability of the subsequent GO. Applicability of subsequent GO, that is, my lord, paragraph number 14 here in it, my lord, read to it. And whereas GO number such and such, dated 6 February 2023 of the Urban Development and Municipal Affairs states that initial appointments, promotions in respect of all other officers and employees not included in subsection 1 of section 54 of the West Bengal Municipal Act 1993 made by the municipality, that is not included by the municipality by 1993, power given to them, that is up to 1%. Against the sanction vacancies between period 14 July 94 to 30th September 2003 shall be deemed to have been done as per extant provisions of the West Bengal Municipal Act 1993 and has ratification of state government. Since the petitioners were appointed in unsanctioned post, their appointment cannot be regularized in terms of this GO also. So this 2023 GO, they also, my lord, resorted to that we are also covered by this. But that is not also applicable, my lord, it has been dealt with here. Now, if your lordship, my lord, kindly come to, my lord, the appointment letter. So for this message, sir, it is there, my lord, the documents. The page 42. Page 42. The appointment letter annexed here to, you are hereby informed that the commissioner of this municipality at their ordinary meeting held on 18th of March 1991 were pleased to appoint you as resident lady medical officer at G&O section on and from the 1st April 91, that is pre-1993, in the scale of pay of 660 and the end up to 1600. Second pay commission, it is initial pay 600. You shall be eligible to get the another. So, and then, my lord, the next page, it's another, my lord, the copy of resolution of the municipality in his favor. That is also, my lord, it carries the date of 6 March 1992. Again, my lord, 1990. Consider the application of Dr. Chandana Bhattacharya. Unanimously resolved that Dr. Chandana Bhattacharya be confirmed in our post with effect from 1st October 91 in the scale of pay 2,200 to up to 4,000 plus all other admissible. So, my lord, it is a fact, they cannot deny that this appointment is held by that proviso. Even if they can say that in view of the enactment, the statutory permission, they are entitled to the municipality up to 1%, but there is a, my lord, the proviso to be read with. And proviso says that subject to that scale of pay, initial appointment. The initial appointment was beyond that scale. So it is not, my lord, so far that particular provision, my lord, giving power to the municipality, that is not covered. So it cannot bail him out or bail her out. Then, if your lordship, my lord,
So
kindly,
in the same argument which your other friend was making, the same argument that they are hit by the provision of 66, right?
now, my lord, I am coming. Now, my lord, kindly, my lord, come to the, my lord, because he said that the Shuktilal Mukherjee's judgment or Shuktilal Chaudhury's judgment that was delivered by the division bench, committee 553. Now, my lord, kindly come to page 89. My lord, many issues was raised there in kindly, my lord, before going through. Many issues were raised.
Yes.
There.
Yes.
Now, my lord, eventually, my lord, court asked the municipality when it was brought to the notice of the court by the my lord, the writ petitioners responded therein that there is a provision with regard to that up to 1% post can be created by the municipality under the old act as well as under the that will repeal that under the new act also. Then the court asked the municipality that to submit a report that on that year or in that year when that Shaktilal was given appointment, what was the total sanction post and how many were my lord recruited by the municipality against this post. Now, my lord, the municipality my lord, came forward and filed a report by way of affidavit. And it appears they disclose that in that preceding year, because always the total sanction post of preceding year, 1% of preceding year, the municipality disclosed that in the preceding year, total sanction post was such and such. And it appears, or it was unearthed, that out of that sanction post total in the preceding year, when Shaktilal was given appointment, total sanction post was supposed 300, and 1% my lord came to 3. And it appears eventually in that year, 3 persons were my lord recruited by the municipality. So the court said that I am not taking any other plea because all those are against you. Against the, the writ petitioner response. But so far this point is concerned, the judgment delivered on this point only. That eventually it appears that only on this point you can be succeeded. And the other point where raised and succeeded by the petitioner before the landed single judge, that was my lord, there no maintenance. But only this point, because of the fact that my lord, the municipality came forward on the basis of the direction of the court, they placed the court there that at that the succeeding year, before the preceding year, when Shaktilal was given appointment, those were the number of post sanctions. And 1% that came such and such. So this, my lord, the appointment valid because it was no more, the sanction was required. So this matter is concerned, in not a single matter, I think municipality has either has been directed or come forward that what was the the total sanction. Because number of posts immediately preceding the year of their appointment of the petitioner are very much my lord essential because of the fact that this 1%, if I go to take it 1%, then my lord, that my lord, the person, my lord, total sanction post is required. Number two is that in the my lord, the repeal act in 1932 act, there was such a proviso with regard to that. That scale should be this, not beyond this. I think in 1993 act, there is no such my lord, the restriction. So even if that ratio, but that is not also not applicable. So for pre-1993, where initial appointment beyond the scale, initial appointment carried beyond that scale.
It's void.
My lord. Now, my lord, people also kindly, my lord, see the Shaktilal. My lord, the Shaktilal, only my lord, only 2 or 3 paragraphs, lord, kindly come to.
Page.
I'm Shaktilal. 89. Page 89.
Yes.
89টা নয় না স্যার আমি জুনিয়রও আমি বলে দিতে পারি আপনি আসুন পেজ 109
Page is wrong page.
109
Yes. Yes, sir. Page 109.
My lord.
But all these arguments would mean that you have only given it to 3 people, but subsequently you have given it to people also. So this argument which you are making today is contrary to your own action.
No.
Yes, to a particular year.
Here, the power given that
1%.
you can give appointment every year, but always subject to the total number of sanction put in the preceding year on that basis.
That's right. So that's why the first day only I asked that how many people are covered and how are not covered.
So
So
the municipality can buy that the chart will be placed by the municipality. Now, kindly come to my lord, paragraph 31, at page 126 of the judgment of the division bench. So,
yes,
paragraph 31. Accordingly, we agree with the conclusion reached by the learned single judge. That is, my lord, the writ petitioner was entitled to. Conclusion. Although we disagree with his lordship's reasoning, therefore, we therefore do not interfere with the order under appeal. We affirm it. And the reasoning, my lord, if your lordship kindly come to my lord, just previous paragraph 29. Paragraph 29.
yes,
From the, that is my lord, 28 process, sorry, 28 first, 28. However, we have to accept the alternative argument advanced by learned advocate for the respondent slash writ petitioner. Enter, my lord, the relief was, my lord, given on the basis of this alternative argument advanced by the, my lord, writ petitioner respondent, not on the basis of the, my lord, the reasoning given by the single judge.
all
So
right.
what was the alternative? That is, my lord, 29. From the affidavit filed by the municipality, the relevant portion whereof has been extracted above we find as on July 1, 1998, that is the year immediately preceding the year in which the respondent number 1 was appointed, there were 341 sanctioned posts in Domdom municipality. Only 3 appointments were made by creation of posts in exercise of power under subsection 4 of section 53 of the 1993 Act. In the following year, 1% of 341 is 3.41. Hence, the municipality, as per the unamended subsection 4 of section 53 of 1993 Act, could have created up to 3.41 posts without prior approval of the state government. Since a fraction of post is incapable of creation, the logical conclusion is that the municipality could create up to 3 posts of officers employees without prior sanction of the state government. We find from the affidavit of the municipality that within the period stretching from 1/1/1998 to 31/8/1998, that is immediately preceding the year of the appointment, only 3 officers or employees who did not fall within the meaning of officers as referred to in section 53(1) of 1993 Act were appointed in exercise of power under section 53(4) of the state Act. And they are Dr. Shukla Chaudhary, Dr. Ashit Ranjan, and Dr. Priyadarshini Sarkar. So only on the basis of these findings, and this came out because of the, my lord, the facts disclosed by the municipality, so far that vacancy position that prevailed during that preceding year of the appointment of the petitioner respondent, my lord, this division bench order was passed solely on that. Now, my lord, my humble submission is this, that my lord, here also, my lord, they relied upon this division bench judgment. Now, even because of that, suppose, my lord, even if they super this pre-1993 appointments, so far the other, this petitioners and others, because there are 2 class, I think, that some belongs to
That Mr.
and some belong to post 1990.
Mr. Sen, let Mr. Rai clarify that.
Now, my lord, the so far pre-1990 who are governed by 1932 Act, even if municipality come forward and say that the position was this, then also they also, my lord, it has to be, my lord, looked into that whether any of the appointment is hit by the proviso to that 66(1).
All right.
So, my lord, my humble submission that after considering all these things, my lord, the order impugned was passed by the, my lord, the director of local police. And whatever, my lord, the writ petitioner, they are relying upon and are resorting to with regard to the judgment of the, my lord, the earlier division bench. My lord, the earlier division bench judgments are not applicable because the facts are totally different.
All right. All right. Yes, Mr. Rai.
The state matters.
Yes, Mr.
I made a considerable note.
Yes, Mr. Yes,
Either the medical officer
yes,
or residential medical officer want the soil. They are appointed with a floor from 18 March 1993,
yes,
31st of 1990 on various dates. My lord, something they were confirmed, they placed in the time chair and they got the US scale of fear.
yes, yes.
Some of them registered their services, some of them some of them they will return. Now, accepted. They will single banks, they will also can come to pay on day. So people write, I just gave the audition and my, so my lord, you must can come to paragraph 5A.
Five,
Bengal Municipal ID that
yes,
posted 18 March 1972.
right,
I have taken the section
yes,
and that was amended in 1980. This question.
yes,
There, I'm not giving, sorry, I'm not going to second provider. Yeah, they are telling us second provider. And I'm not. And although municipal, like I came into court on 31st March 1994, Queensland to repeal, so after this, after four, then was amendment, my lord, 2nd September 2022, this, my underline was first, deleted. This, if the number for that was deleted after 2nd September 2021. I mean, then,
yes,
so my lord, that two acts were there. 1990 Act was there the provisions, then that was subsequently amended by in 2002 March. This is the fact situation. Now, my lord, when this issue moved, earlier issue moved, then it basically relied upon to serve. Cross can come to place unless. Single bench judgment will start March 2022. Actually, they should be up to this.
yes,
The major move, they basically add upon two circulars. 100 feet.
yes,
They will have a circular 100 feet and 104. On the basis thereof, the oral citizen deliver the charge and allow the decision. And the point was taken because after that they rendered the services, they got the bill of get salary. Why they will not get the bill? A state has come and appeal. The more issue is if the person concerned doctors, which were not appointed in the sanctioned post,
yes,
whether they are entitled to get the benefit of it. The
moot question.
now appeal their rights. Then my lord rates and the and lord back to the 93 Act. And my learned pen, my lord, added to the points of the 1932 Act. This is also one of the corporate. I my lord.
Yes.
So can come to 54. Number 54.
টাইপ কপি আছে স্যার,
That would have been-
টাইপ কপি আছে, টাইপ কপি আপনি কোনটা করছেন, কোন লিপিটা করছেন? না না, কোন কোন ডাব্লিউটি এটা করছেন?
Type copy page 67 on.
Yes, yes.
73 also. But these would have to accept here. Facts that the little name is Dr. Devanjan Krishna.
Devran-
Yes,
Devran-
Devan.
yes,
He was appointed 29 April 1983.
yes.
But this is the 69 appointed.
স্যার টাইপ কপিটা 68, টোটাল টাইপ কপি। অরিজিনাল আচ্ছা আছে।
And 29 April 1983, that person was appointed.
Yes,
So he was appointed, under the 1932 Act. My lord, Colonel Singerman was, so Shah's can go to the High Court. Singerman directed to give the, consider it a pension benefits. Municipality has come, you know, appeal. It's an appeal of municipality.
hmm,
And one can see the commission, what my analyst said, that has only dealt with the division bench. If yours can come to. Page 63. Okay. Can come page 63.
ইন্টারনাল পেজ
And the basically, the landed council for requisition has drawn our attention to the provisions of municipal act. Into there would be appropriate state note of the position. When this state system became, because the same clearly gave a right of the commissioner of municipality not only to determine what officials are necessary for the municipality, but also gave them the right to create post of such officers and to fix their salaries and allowances. A post of officers will be created by the commissioner under subsection of six, included the post of medical officer on the case. Under this case 64, upon provision as contained in section the Bank of Act, we have the view that all relevant point of time when the respondent now was appointed and commissioner of municipality that appointed the you know what is case that post on which he was appointed was more than 1% of the total number of posts as contributed the first provides section 66. So my appeal was dismissed. So this is a fellow division when only there is no more dressing triggers, one was all set. So all that one was settled by the individual judgment and the new act was settled by the
that,
SOP. Now this is the one, the social judgment has given you also. That given a case also. This is at page 210 to 2028 of this speech.
yes,
From will say authority part of the judgment is not paragraph 29, 30 and 31. This is page 226. Yeah. Not 26. So this is all absolute law. This is the background. Now I just one by one step I just.
yes,
You can consider my note. Page 3.
yes,
First petition. Filed by Ashit Ranjan Kundu.
yes,
I have given my law. Up to. On Shoktilal in 1998. Because I was 1998, Ashit Ranjan Kundu. On the and on the very same day, he was actually shot.
yes,
He was not appointment.
yes,
in the 1997, and see,
Yes.
on record, my lord, I have
Yes.
given my evidence opposition 341 post-sanction posts. So 3%, but 3% can be the post can be created in insurance and can be appointed without sanction of the state house.
Yes.
So those 2% are coming with the journal council.
Correct.
So here the OC has coming. Next, my lord, here's some difficulties. Next one, look at 163 second matter.
Yes.
Here you can see in 1994, 3% were appointed. One, Shubhendu Homi,
Rafiqul.
sorry, one Shubhendu Homi, and 26, he got already, he's indicted, 26, February 1994, Dr. Rafiqul Hassan and Nitya Gopal Vishyan got appointed. And fourth is Amlan got in 1994. In 1993, there 200 sections.
So only 2 posts were there.
So first one, my lord, I mean, second one, my lord, the legal picture, both on the same day. I just paid you lawsuit, but 200 sanctions for, so. Robbie police are not, both are, and Amlan in 94, he is not 300. Under the section of the 4. And next one is WPS 16302, Vidhan Chandra Mondol,
So there's no problem with this.
there is no problem. Now,
Nitya Gopal.
Vishal, he is my lord, wife of Nitya Gopal Vishal. Same problem, my lord.
Same problem.
People and so both are appointed one post.
Four appointments, 1 post.
Now, my lord, next Amlan, next one, he is also the because he is the fourth person. Enemy of people and Mr. Gopal, there is some legal fiction, but he is not coming under 2 posts. And next one, PROCEEDINGS is coming. Because in 98, they think I given the chart of. In my 16840, Shubhodhi Bhattacharya is coming. Because I have checked up my law in 96, the 2002 post action. So he's also coming. And
Amitesh sir, one is one you missed out, but it's covered. It's okay.
and my lord, next 2 matters, they are also coming. So they are 96 months under the 6 and that is to act, that is 2 months. I give the list of, there is 204 and the only problem.
Two.
I also blame, but the position.
Lord, so far as the contention of my learned friend is concerned, I expect only 2 posts, my lord. I'm to some extent covered by lordship's own order. Because in a similar matter, lordship has held, my lord, in order, own order.
Those pre-93 posts.
Kindly allow me to go through the finding of your lordship. Lord, in the internal page 6, my lord, from the legal analysis, if I proceed, allow me to read. The court has heard the arguments advanced by the learned counsel by the parties and perused the documents. This case exemplifies a clear instance of administrative negligence wherein various instrumentalities of the state are engaged in shifting blame onto one another. Regrettably, the ultimate victims of this bureaucratic blame shifting are the retired employees who are dedicated over 3 decades of loyal and
All right, all. I know this, sir.
Ballot has directed to create a supernumerary post for the time being to accommodate them. And in respect of these two persons, my lord, they have enjoyed my service to the fullest tenure.
Okay, heard. CV. All 10 matters.
Great.
No, thank you, Mr. Very helpful. Thank you. Thank you so much because Ms. Bawal is very competent. Thank you.
Great.
Ms. Bawal, you give your details.
That is not my part.
Yeah.
Grateful, my lord has given a patient hearing.
Great. Yes, next. Just give your name and number for hey, इसको ना receiver वाला जो list है उसमें डालना. Next.
Item number 11.
ये वही है ना? 11 and 12 are together. Yes.
They were supposed to make their submissions from the state.
Yes.
Though accommodation was sought for,
I know.
though accommodation was sought for on the ground of my learned senior Muller, but I'll have to take up the mantle today because he's otherwise occupied today, Muller. Muller, just to refresh your lordship's memory, Muller, here an order, reasoned order of the HMC. Reasoned order of the HMC, Howrah Municipal Corporation is under challenge, where 17-point conditions have been imposed upon the petitioner, that is the developer, that is the writ petitioner in the first writ petition. Sir, একটু জুনিয়রটা আমার জুনিয়রকে ক্লাস The other writ petition, Muller, is of the owner of the land who has entered into development agreement. Now, Muller, if we bifurcate the two cause of actions, as far as the developer is concerned, the developer is not going to stay there. Developer is going to develop and sell off. So, as far as he is concerned, it is his trade and business. I'm sorry, Muller.
I appear for the petition nominal. Let Mr. Bandyopadhyay make his submissions.
Sir, আপনি বসুন না না এটা ধাক্কাধাক্কি হচ্ছে আমার বলতে অসুবিধা হচ্ছে আর কিছুই হচ্ছে না So, Muller, as far as the developer is concerned, it is his right to trade and business. As far as the other writ petition is concerned, he may at best project a case of right to property. Though, Muller, I have gone through the development agreement, both are having a share of 50-50, Muller. My learned friends will correct me if I'm wrong. If the owner also says that this 50% I am also going to sell, then his right will also fall in the bracket of right to trade. The Muller, your lordship will kindly take my submission in these two brackets. One is the right to trade and the right to enjoy the property. Now, my lord, before going into the legal arguments, my lord will kindly take in the first writ petition, kindly takes my lord page 130. My lord, I am not aware if your lordship's brief, my lord, in the page is quite legible or not, my lord, because I have a rather illegible copy. I have other copies also, fresh copies, my lord, if required.
There's the notification.
There is notification, my lord, of the Home and Hill Affairs, my lord, declaring the Novanno building, there is the HRBC building, my lord, as a security zone. Fresh copy to fresh copy to it has become smart. So, my lord, your lordship will find that this has two parts to it. The first part is that the government of West Bengal in the Home and Hill Affairs Department, for the purpose of security and safety of the land and buildings and its adjoining areas, hereinafter referred to as the said area, as specified in the schedule below, deems it necessary to declare the said area as security zone, and the said area shall be subject to the control of the Commissioner of Police, Kolkata. So this is the first part. One is it is declared as a security zone, and that it will be subject to the control of the Commissioner of Police. The second part is that, and whereas the government of West Bengal in the Home and Hill Affairs Department further deems it necessary to prohibit and or restrict the sanction of any building plan exceeding 15.5 meters of height from the ground level within 500 meters radius of the said area for the purpose of safety and security of the said area. Now, my lord, this in exercise of powers conferred under section 243, read with 244 of the HMC Act 1980 and subsequently amended, the governor is pleased to hereby declare that with effect from the date of publication, from the publication of this notification in the official gazette, that the area as specified in the schedule below shall be treated as security zone and prohibit the sanction of building plan exceeding 15.5 meters of height from the ground level within 500 meters radius of the security zone. So, my lord, if I have understood correctly, my lord, this notification is not under challenge. My lord, they have made their building within 15.5 meters. Now, my lord, the only grievance is with regard to whether the other conditions can be imposed upon the petitioners or not. Now, my lord, before going to that aspect, that whether it is legally permissible for me to impose that condition, to request the Commissioner HMC to impose that condition for sanction of the business sanction plan, because I have not imposed it, I have only made a request and the HMC has made it part of the recent order. Now, my lord, kindly first sees what was their stand contemporaneously, my lord, when this entire issue was pending before the Howrah Municipal Corporation. Now, my lord, your lordship will find several representations, rather cyclo-style, but kindly takes one of few of them. Kindly takes, my lord, page 131, the representation starting at page 131. And my lord will kindly come to page 134, which is paragraph 22 of the representation.
Yes.
My lord, for the sanction of the building plan, kindly sees what they have undertaken. That the company is ready to all the mandatory directions. If the
Wait a
authority,
minute, 134 you are reading, right?
134, my lord. There are actually two paginations. One is 132 and 134.
So 134 is serial number 14, 15.
My lord, 134, my lord.
The last one, my lord, at the bottom, that the company is ready.
My lord, the bigger now,
The
new
company is ready to, okay.
20,
Number
paragraph 22.
22.
Paragraph 22. The company is ready to all other mandatory direction if the authority direct for the completion of the project work, as because the same is pending from the year 2019 and the owner became very so and so regarding the completion of the project work, so the interest of the owner also to be looked after. Then kindly comes to paragraph 25, next page. That as the company adopted all the rules and regulations as directed by the authority and complied the same accordingly, and or undertaking to comply all those formalities from time to time as will be required, so it is my humble prayer that clearance of commissioner be issued accordingly, otherwise I will suffer seriously, and not only financial part, etc. Therefore, they undertake in 2020 that if any further conditions are to be imposed upon them, they will follow that in lieu of the sanctioning of the building plan, because it is pending for some time. Now, similar undertakings your lordship will find in the representation at page 136, which is made to the Commissioner of Police, and your lordship kindly comes to page 139.
The same paragraph, I'm not reading it, my lord.
Similar.
Same.
Same.
Not only
Actually,
similar, same.
verbatim.
Verbatim, my lord. 22, and the next page is 25. Now, my lord, in the meantime, the petitioner, the second petitioner, comes before this honorable court in WPA 12496 of 2024 for demolition of his building. The other petitioner comes, the owner comes. That is page 170.
Yes.
The petitioner seeks permission from Howrah Municipal Corporation to demolish his residential house at 80 by 2 Khetromohan Banerjee Lane, POPS so and so. Then the kindly skip. So then the corporation submits the building should be demolished by petitioner himself in the presence of so and so. The petitioner has no objection to the stance of the corporation. He wants to engage so and so, a chartered engineer, and under whose supervision the demolition work is to be carried out in the aforesaid facts. I direct the petitioner to undertake the demolition work, giving due notice to the corporation. The corporation should monitor the demolition work. Now, there is a short precursor to this order as well. If your lordship kindly takes one of their representations made again contemporaneously, not by the developer, by the landowner. But if your lordship takes the other writ petition once, but I'm very sorry to take your lordship back and forth, but this one document will be necessary. Otherwise, all documents are here.
Another one. Yes.
But kindly takes page 63, a representation at page 63.
Yes.
But kindly takes page 65.
Yes.
Accordingly, it is humbly requested, last paragraph.
Yes.
Accordingly, it is humbly requested that necessary permission may be accorded to demolish the existing structure. It is needless to mention that the developer have claimed that the application for grant of sanction is pending at your end. But presently, whether at all the same is sanctioned or not is not relevant. I am also taking steps against the developer for contravening the clauses of the development agreement. For the time being, it has become necessary to demolish the said building for the purpose of safety and security of the individuals. Accordingly, immediate steps on your part to accord such permission may be demolished is required. Therefore, my lord, his stance contemporary is that it does not matter to me whether the building plan is sanctioned or not. I only want the demolition of my building. This case of this, after the order of the coordinate bench, in the earlier round, as an afterthought, they changed their case. And now they have set sail along with the developer that you sanction the building plan, otherwise I am in distress. But this was not their case initially when they approached this honorable court and
But Mr. Bandapande, how is this relevant for the purposes of putting these
I'll tell you.
conditions which are
Both the stance of the developer and the owner. First of all, the developer agrees that for sanctioning of the building plan, if you impose certain conditions, I have no difficulty. And the developer is saying that whether the sanction plan is given or not, that is also I am not bothered with that.
No, that owner is saying that whether the sanction plan is given or not. Page 63, which
So he says he knows his remedy. He says that whether the sanction plan is given or not, it is not a botheration to me. I will take steps against the developer. Today he has changed his stance. Today he says that no, the sanction plan should be given to me because I am in some difficulty. What I am trying to point out is that that was not his stance when he came before this honorable court. Therefore, the demolition and the non-sanction of the sanction plan.
It's not relevant. When
It
he
is-
came to this court, he's asking that the conditions which have been affixed with the
Reasoned order. Yes, it is what is important to be seen here. Number one, as far as the developer is concerned, the developer agreed to this. The developer agreed that if you put any conditions, I have no difficulty with regard to that.
But he has come to the court because he has difficulties.
Today he has.
Maybe whatever he has written is a question.
Today.
The past. Today he has come to this court. We are only analyzing whether those conditions which you have put can be put or not.
Whether I had the right.
Within the legal framework,
Fine.
within the parameters of law, can those conditions be fixed or not?
I'll tell you, Lordship, as far as the developer is concerned,
We will not go into the conduct of neither the
Very
developer
well.
nor the owner.
I'll
They
not
are
trouble your
connected.
lordship with that argument. Well, the developer is projecting a case under 19(1)(g). Well, 19(1)(g) is subject to reasonable restrictions under 19(6). When? But kindly Mullah takes when? Kindly takes Mullah 19(6).
Read it out.
Yes. The constitution to the
Yes.
nothing in subclause G of the said clause shall affect the operation of any existing law insofar as it imposes or prevents the state from making any law imposing in the interest of the general public reasonable restrictions on the exercise of the rights conferred by the said subclause. Rest is not important for our purpose. Therefore, the question is whether the restrictions which has been imposed upon him, number one, are reasonable enough or not. Number two is whether it is in the interest of the general public or not. Now, my lord, the way the security system of our country runs, and we have also made out that case in the affidavit in opposition, my lord. My lord, there are designated security codes for designated personnel. We have mentioned in the affidavit also. I'll take your lordship through that paragraph, my lord, to give context to my submission. My lord, as far as the security of the dignitaries like the president, the vice president, the prime minister, chief minister, the judges of the Honorable Supreme Court and the judges of the high courts are concerned, my lord, those are covered by the yellow book. And then there are other security arrangements which are covered by the blue book. Now, my lord, we have not annexed the yellow book, but we have craved leave in the affidavit to produce it. As your lordship can very well understand, those are on the bordering on the security and the safety aspects of the dignitaries. So we have not produced it. What is contained therein, perhaps in judicial review, your lordship will not look into it because that is not the challenge also. Your lordships will also not look into the aspect whether the authorities think that there is a particular threat perception regarding a particular dignitary is there or not. Malad, it is in this, it is
Not
not
not-
in the judicial review, and that is also not part of the challenge today.
that's not part of the challenge.
And Malad, admit,
Judicial review, whether I can see the threat perception or not, that is something which can be seen.
but Malad, your lordships will, in a given case,
Threat perception always is looked into by the courts.
yeah, no,
Mr. Bandhu.
Malad, what the Supreme Court says is that it is better left to the authorities.
That's right.
But
But
if
that is something which can be looked
yes,
into.
but if suppose, Malad, if I may frame it in a way of an example, if
There we are not concerned.
if a private person comes and says that you give me police
Always
protection,
does that.
always does that, and if it is, Malad, your lordships can always see
So is
that whether that threat perception we have rightly
genuine or not.
genuine or not, and when we are saying a person
That is the time when the review of the threat perception is done.
is judicially reviewable, and a person when the state is saying that there is no threat perception, but your lordships can feel that there may be some threat perception, your lordship can always, either way, when we say yes or no, either way it can be done. Therefore, Malad, but as far as Malad the dignitaries are concerned, Malad, it is a set formula which is applied throughout
The job less, it's not our job at all.
Yes,
The
yes,
state's
absolutely.
job.
Therefore, Malad, where it is also an admitted fact here that this building is overlooking or simultaneously looking at the secretariat. It is not only the case of the chief minister, but there are other IAS officers are there, chief secretary is there, other ministers are there, other departments are there, or most of it is housed in that building. Now, Malad, the right which is being, Malad, canvassed before Lordship, Malad, the question is that they have a right to trade. I have a right to impose reasonable restriction. But question is that whether they have a right to ask for the right to trade at a particular place, at a particular time, in a particular manner or not. If that be so, if the right to trade includes their right to do it at a particular time and at a particular place, then Malad, all these plethora of judgments regarding the hawkers will never come. Malad, all these orders have come of the Honorable Supreme Court, Malad, only because they have a right to trade, but not at a particular place at a particular time. it is not a case where their right to trade is being prohibited by the state. It is a case where their right to trade is only being regulated by the state. The regulations are these 17 pointers, which has been given to the HMC, and HMC has thought it fit to incorporate in the recent order. Therefore, my lord, your lordships will have to weigh whether by putting these conditions, their right to trade has been completely prohibited or not. I say by putting these restrictions, their right to trade has not been prohibited, but only regulated. Now, my lord, if I may,
Only few are being challenged. Restrictions, what are
my lord,
those?
I believe 4, 5, 16 and 15 and 16.
4, 5.
But I'll come to them individually also, whether it is inner nature that 4, 5, 16, 17.
No.
4, 5, 15, 16. 4, 5, 16.
5, 16.
I'll deal with those also, and I'll in both the cases, both the brackets that I started with, my lord, how the impact on that. But I'll try to canvas before your lordship, my lord. But question is that, my lord, if I may give an example,
Yes.
my lord, say number 5, that there shall be no windows or balconies facing the secretariat. Well, let us take an example of North Kolkata. Well, I do not know whether your lordship has gone there or not. Well, the buildings are adjacent. Well, I'll give an example. Well, north of Jamuna, Wazirpur, Ashok Vihar, those areas I'll give an example. Similar is the situation in North Kolkata as well, my lord. Well, in Wazirpur, your lordship will find buildings adjacent to each other, where on the two sides where it is adjacent, there are no windows. The windows are either at the back or at the front, either facing the road or the backyard. But
Because
it
there's no
is
space.
because they are all sandwiched with each other and one after another in rows until a temple appears suddenly. So, my lord, or a park appears suddenly. So, my lord, same with Ashok Vihar also, my lord. So, my lord, it is not that the building is not livable. It is only that one side should not have a window or a balcony which can be accessed. The question is that whether there is such a prohibition which makes their whatever, my lord, the flat or the condo that they are making non-sellable. Is it such that it cannot be habitated at all? It is not a case where we are saying that do not have windows on 4 sides of the walls. Nowhere there can be a window. It is not so. But when in a building, if there are 3 flats or maybe 2 flats, the 2 flats will join each other at some place. At that side, there will be no windows. Because my window will open into another person's flat. So it is not something which has never happened. It is not something which will never happen. There will be flats where on one side there will be no windows, no balconies, no doors also. Nothing. So it is not something no one can think of.
But that's a different scenario. When you're looking at the building bylaws, you have setbacks. You have front setback, you have rear setback, you have side setbacks. So a lot of times, like even in Delhi, not only Ashok Vihar or anywhere, even in the bigger colonies, the plots are adjacent to each other. And on one side, you can't have windows. Right? You know, but the fact is that you have to leave rear setback, front setback. Those are conditions which are there.
And side sets, that is not left actually.
Not left.
Not left.
Not left. So side is
Is just
it's covered. So there's no space in between the two buildings. You know, it's literally
And
the same wall which is
even if there is space and even if there is a window, it cannot be opened. Because it is very close to
Not
the
there.
neighbor.
not there. I mean, I can tell you about
So, what the point I'm trying to make here is that it is not something which is unthinkable of. It is not something that no one has thought of.
here you're talking about restrictions.
Yes, regulation. I am
Regulation.
I am trying to differentiate between regulation and prohibition. It's a different matter, my lord. I can go into that argument that regulation includes prohibition also. Here it is not so. We are at a better case where regulation means regulation. We need not go into the discussion whether the regulation includes prohibition or not.
Prohibition or regulation?
Regulation, if regulation includes prohibition and we have fell short of
Difference
prohibition.
between prohibition and regulation. See, like let's take the Archaeological Survey of India Act. There's a prohibition within 100 meters you can't construct. There's a regulation that within 200 meters you can construct
With
certain-
so and so guidelines.
certain guidelines. So either it is completely prohibitory in nature, or there's a reasonable restriction with some guidelines.
Your lodges will find a line of decisions where it says that the regulation, if I have the power to regulate, I have a right to prohibit also. But it has to be reasonable enough. When it is so much
I wanna see the
outweighing,
key. That's the only, you have hit the nail. When you say this, I want to see the power from where you have this authority.
but the power is 19.6. The power is 19.6. And question is why it is being applied. But if it is being applied, if it is being applied because my lord of the notification and declaring it as a security zone. Because my lord, the building rules of the corporation, building rules otherwise, my lord, does not contemplate this situation at all. If the government home affairs notification does not come declaring a particular place as a security zone, there will be no requirement to put these conditions at all. Therefore, my lord, the reasonable restrictions has to be put in. The only question, my lord, is whether it is in interest of the general public or not. Because, my lord, the reasonableness I can show. Because another thing, my lord, I found from one of the points there in the 17 point that their language take here. No, no. My lord, like serial number 4.
Just 1 second. Which page is that?
That is in the first writ petition, that is page 179.
Yes. Yes.
A 10 feet high view cutter should be constructed around the roof of the building. Now, my lord, if it is not there, then the roof has to be under surveillance all the time. My lord, if a building that high stands near the secretariat, there has to be some surveillance. My lord, the only thing is that to stop that surveillance, this is required. Now, my lord, we were exploring an option whether it can be given on one side or not. But even if it is given on one side, then also, my lord, from the other side, my lord, constant monitoring is required whether the other sides are being utilized or not.
Let that monitoring take place, please.
This up to this, if they are agreeable to half of it, we are agreeable to half of it. So one side they can keep open, one and half of two sides. But the one side, as far as the secretariat is concerned, my lord, that has to be 10 feet view cutter has to be there. And the other one, my lord, is.
But what about, see, this is not the standalone building over there, right?
This is the building, my lord. Coming, your lordship, my lord, if I've understood the question correctly, that why only this building? No, my lord, this building is coming up after the notification.
Only this is the only building which is coming up after the notification.
Within that vicinity. There are other buildings that also have inquired that those were old buildings which had already come up previously. Therefore, my lord, there was no question for us to approach the agency.
Those buildings which are closer to the
Secretariat.
And probably the threat perspective would be similar to this building. So after this notification, you could have asked all of them to put a view cutter, 10 feet view cutter.
My lord, for a 2-storied building, even a 10-foot view cutter will not be enough.
Have you placed security personnel in all the roofs?
But security personnel should be there, my lord. I have not taken exact instructions, but I am sure it's there. I am sure it's there, my lord. That kind of surveillance, I am sure is there. But my lord, why it has not been done in that case?
They will also agree to that kind of surveillance.
This is the building, my lord. It's not 2-storied, it's a 4-storied building.
All around the place, there are more than
allowed to be
2-story buildings.
Kindly see the ICICI banner has been allowed to be put up. And from nowhere, your lordship will see that the windows are not facing the Navarno. We have made a plan which shows that the adjacent building is much closer to Navarno. And they have allowed without a view cutter, ads to be published at the top floor. Kindly have a look at this.
The other answer to that is that all has been done prior to the notification.
No, this has come up recently. We have inquired, my lord, we have specific instruction that these boards have been affixed recently. And there is no restriction on that.
But I'm sorry, my lord. My junior did not instruct me that the petitioner did not conclude. So I started making submissions, my lord. I'm sorry, my lord. I hope he doesn't bring out a newspaper the next round. Because had it been in the pleadings, I
No,
would have
that was only to, my lord,
to disturb the submissions.
no, to substitute what you are saying, nothing else.
Is this the way you have told him to submit in the middle of the
No,
submission?
no, I have not told him anything. It is just to substitute what you are
Mr.
saying.
Bhattacharya, kindly stick to what you have taught us. Do not defend him now.
He has defended
My lord.
Yes.
Now, my lord, the other, you said 15. Serial number 15 or 16?
16.
Now, my lord, as far as 16 is concerned, but there can be, I do not understand that where their difficulty lies if the character antecedents are checked.
And that is a big one.
No, my
That
lord,
is a big one.
my lord, the question is that
There's no question. You
my
can't.
lord, if today, my lord, kindly forgets about this matter.
I can still understand some bit of security, restrictions. But 16?
My lord, as far as the dignitaries are concerned, I'll show, my lord. It does not require a threat perception at all.
You can't put a condition on a person
See-
who he can sell the property to.
My lord, then my lord, the question arises that whom did he intend to sell at all?
Doesn't matter. None of your concern.
My lord, it is. My lord,
That is not even
if it is in the vicinity of the secretariat, my lord, why is this point pinching them so hard? My lord, that is the question which has to be asked. That where is the difficulty?
I am asking that.
No, my lord, I'm trying to.
Because when I see this clause, this looks slightly unreasonable.
My lord, I'm only trying to show the reasonability of it, my lord. A building is coming up, my lord, in the vicinity of the secretariat. My lord,
So
this
you will
has to be read in conjunction
you
with
will
the other
regulate
clauses.
the builder or the owner to rent out a property, sell a property based on all this. That antecedent has to be checked. Suppose my antecedent is very good, but I decide to do something then.
My lord,
What is the purpose? What is the reasoning?
but
What is
even the
logic
my lord, the Kolkata police goes
And
to
what
the
kind of
extent of saying,
antecedents you are checking?
if the Kolkata police goes to the extent of saying that an awareness that if you are keeping any staff at your house, that also please inform the local PS.
Different things.
Therefore, my lord, even
We are talking about a right of a person in a property, a fundamental right which he holds to sell it to anybody. We are somewhere interfering with his business.
no, he can sell it to anyone. My lord, kindly, my lord,
Antecedents can't
my lord, kindly, my lord, looks at it this way, my lord. Whom he sells, it is his concern.
No, it's
what-
not his concern. That is a
But what
clause
we
which
are
you
saying
have
is
put.
that we want to see the antecedent of the person. But it is kindly, my lord, read the clause. Character antecedents of the dwellers should be done by the authority and should be repeated in case of new dweller. We are not saying that don't sell, but we are saying that inform us. We are not stopping them from selling. It is not a proposed buyer. My lord, kindly marks the word. If someone is dwelling there, you inform us so that we can do it. We are not saying that you can sell to X, you cannot sell to Y. Even if, my lord, someone keeps a tenant, it is advisable to inform the local police. Then I ask this question to myself that why is this difficulty in informing that this person is buying? My lord, the data is not something, my lord, which is not otherwise cannot be taken by us. The registration is also before the state authorities. The data is before the state authorities.
Somebody who is involved in a 138 matter, will you allow? You will decide.
My lord, you mean,
What are the grounds?
my lord, we will.
You will verify the antecedents. So what are those antecedents which you will permit and which you will not permit?
No, my lord, we are not permitting or not permitting. We are only being cautious. If we know that there is some antecedent where we need
Antecedents. We all
antecedent,
get stuck.
antecedent,
Yes.
then we will be cautious of what is happening. It is for our preparedness. We are not restricting anyone to buy or sell. We are only asking for the information that whom you are selling. We will do the check ourselves. Now, my lord, question, my lord, which I was trying to frame, my lord, whether ওটা এসছে ধারামচান্তা কোথায়? রণবীর উপাধ্যায় লেখা আছে, মাথা খারাপ হয়ে গেছে নাকি? My lord, if your lordship takes one judgment, 2015-10 SCC 612. 15-10, I'm sorry.
Yes. This is Dharamchand.
But kindly take paragraph 13. May I please it, my lord? In pursuance of this court's order, the Secretary General, Supreme Court of
You
India,
know,
and the
Mr. Bandyopadhyay, that Samrat Hotel, where you have the offices, including the CBI office and also TDSAT. It used to be. I don't know where TDSAT is today, but there were floors which were not to be used. You can place Samrat Hotel, right? Right
Yes,
behind
yes.
Ashoka.
But my lord, I think, my lord, it fell from your lordship on the earlier location also. We tried to see if we get anything on that material.
Nothing you could.
We got this with regard to the Supreme Court, where, my lord, the right to trade around the Supreme Court was prohibited. In pursuance of this court's order, the Secretary General, Supreme Court of India, and the Deputy Commissioner of Police filed their respective affidavits, copies of which were served upon the appellant and the respondent interveners. In the affidavit filed by the Deputy Commissioner of Police, Supreme Court Security, it has been submitted inter alia that it is only after the bomb blast outside the Delhi High Court on 7th of September 2011, a meeting was called by the then Chief Justice of India and this court on its administrative side after deliberations with the Delhi police prohibited vendors to squat along the perimeters of the Supreme Court. Similar affidavit has been filed by the Secretary General, reiterating the same in para 2 of the affidavit about the incident which took place in 2011. And thereafter, the security arrangement was reviewed with Delhi police and a decision was taken on the administrative side not to allow hawkers near the Supreme Court premises. Now, my lord, kindly comes to paragraphs 18 and 19. After giving our anxious consideration in the matter, although we have sympathy for the appellant, but there are various circumstances justifying the refusal to permit the appellant to run his business in the kiosk in question. Notwithstanding the constitutional right of a citizen to carry on business, but such right is subject to certain restrictions. It cannot be disputed that there are certain areas which may be required to keep free for such types of kiosks for security reasons. The court cannot direct the administration to allow such kiosks even if there is a threat to the safety and security. On one hand, the appellant has a right to earn his livelihood, but on the other hand, there is a serious issue of safety and security of the premises near the Supreme Court compound. Hence, the court has to balance between the two. The purpose involving general interest of the community as opposed to the interest of the individual directly or indirectly has to be balanced. Merely because of the contention that the appellant and the respondent that after the bomb blast took place in Delhi High Court compound in 2011, no such incident happened till date. It cannot be presumed that such incident will not happen in the near future. The court cannot assume and presume that there is no threat to the safety and security of the Supreme Court and its vicinity and allow the appellant to continue the said business. Therefore, my lord, if there is a competing right of an individual interest and, my lord, that of the public purpose, my lord, the courts must weigh in favor of the public purpose. My lord, we cannot say that no threat is imposed because of the coming up of the building. It is not for us to say. But we are belonging to a nation, we have lost 2 prime ministers and 1 father of the nation to assassination. We are only competing with USA, my lord, 4 presidents have been assassinated. So, my lord, it is not for us to assume and presume that there may be a threat perception, there may not be a threat perception, something may happen or something may not happen. That has to be left to the administration, my lord. My lord, we can deliberate, my lord, whether it is so unreasonable that no one can think of it. And some grounds also have been made out, and rightly so, for the petitioners, that it has those conditions have been given to delay the sanction plan. But I ask this question to myself whether at all it inures to our benefit to delay someone's sanction plan or not. My lord, we were also part of the hearing. The joint commissioner acting on behalf of the commissioner has given a letter saying that these are the 17 restrictions which should be imposed on the construction of the building, and accordingly you sanction the building plan. And at the cost of repetition, my lord, nowhere, if your lordship sees that letter, nowhere it is prohibitory. If your lordship takes my affidavit in opposition once, in the first matter,
In the first matter,
my lord, your lordship will kindly first take page 15 once.
yes, page
15. But it is a affidavit by respondent numbers 1 to 3.
Mr. Jafar Kidwai. Yes.
Jaffer, yes. My lord, kindly cease.
Yes.
The conditions are the same, my lord, I am not going into it. With reference to the above, this is to state that as the building falls under the security zone in the vicinity of Nabanno NOC is granted, subject to the conditions mentioned by the Director Security, West Bengal, the Commissioner of Police, Howrah, Joint Commissioner of Police, Security, Kolkata, and the Deputy Commissioner of Police, Reserve Force, Kolkata in this regard. So this is the NOC being given, which they wanted from us, but our NOC is subject to these conditions. We are nowhere trying to prohibit what they are trying to come up with, what they are trying to do, and how they want to sell it. They are no way prohibitory in nature. But while your lordship is in looking at the affidavit, your lordship may also take note of one paragraph, 3J at page 6. I'm sorry, my lord. I'm sorry, my lord, page 5. 5G. In fact, sorry, my lord, 3G at page 5. The security related suggested measures like installation of CCTV, putting view cutters, verification of character and incident of dwellers, parking issue, access control are derived from the general security guidelines contained in the Yellow Book issued by the Ministry of Home Affairs, Government of India, which is a reference book relating to the security arrangements to be made for the protection of individuals who have been provided with categorized security of Z, X to Z, and based on work experience with respect to VIP security issues. The department craved leave to produce the Yellow Book. Then H. It is stated that the Nabanno approach ramp road shall absolutely be in open access to the proposed G+4 residential building if the safety measures as laid down are not adhered to, creating an imminent danger to VIP protectees while traveling to and fro Nabanno. Identical scenario shall be caused with the VIPs having windows towards the said G+4 residential building. The meaning thereby, my lord, the drop-off point will be absolutely viewable with an unrestricted view from the building unless this 4 and 5, serial number 4 and 5 in the conditions are not put. Same will be the situation from the window to window of the Nabanno building. Then, my lord, kindly takes J. Next paragraph, J. It is stated that the police is the expert body for as far as determining the threat perception is concerned based on the information made available to them through the intelligence and special branches. Such information and details are confidential in nature and cannot be shared in public. In view thereof, the Honorable Court may not interfere so and so. So, my lord, these are the three grounds, my lord. We say that the restrictions we have put, we have derived from the yellow book, my lord. If required, if your lordship wishes to see it, my lord, we can, my lord, produce it before lordship, my lord, for your lordship's eyes. My lord, these are the grounds which is the foundation of the 17 points. Now, my lord, as far as the Z category protectees are concerned, give me that judgment. Kindly takes, as far as the VIP protectees are concerned, kindly takes 2015 volume 13 SCC 270. 370. 15 13 SCC 370. Yes. Kindly take paragraph 6. Just above placetum E. But what exactly? Just above placetum E. But what exactly is his threat perception and whether the same is grave in nature obviously will have to be left to be decided by the authorities, including the authorities of the state or the center, which may include even the intelligence bureau or any other authority concerned which is entitled to access the threat perception of an individual. But insofar as the court of law is concerned, it would obviously be in a predicament to come to any conclusion as to whether the threat perception alleged by a person claiming security is grave or otherwise, which would hold him entitled to the security of a greater degree, since there is clearly a question of factual nature to be dealt with by the authorities entrusted with the duty to provide security after assessing the need and genuineness of the threat to any individual. Now, my case is a bit higher here because as I submitted, Malad, in case of certain dignitaries, which will clear from the next judgment, Malad, this exercise, Malad, is already inbuilt. This separate factual finding by the authorities is not required at all. And Malad, at the cost of repetition, your lordship will look at it not only being the seat of the chief minister only. There's other officers and other ministers also who are also protectees, may not be Z category protectees. But if your lordship takes the other one, that is Punjab and Haryana, একসঙ্গে নিয়ে রাখ না, একটা একটা করে চাইছিস কেন? এখানে দিয়ে দিন না সব কটা, আপনি নিয়ে নিয়ে ঘুরছেন কেন? ঝাড়খণ্ডটাও নিয়ে রাখ, ঝাড়খণ্ড নয় এটা। সবকাজটাই ডেলিগেট করে দিচ্ছি সঙ্গে। বলো, this is 2022 SCC online Punjab and Haryana 2028. এটা 2028 2028 2028. Malad will kindly take paragraph 16. (16 to 20), Malad, some bits are missing. There are certain quotations which are not required. I'll just skip over those. 16. In the instant cases, Malad, your lordship, in the instant case, as per the norms, the number of police personnel for the former deputy chief minister are 1 security in charge, 6 PSO, 3 escorts, 8 house guards, and 1 escort vehicle. That is 18 police security personnel in total. The Government of India Ministry of Home Affairs has issued Yellow Book, which pertains to the security arrangements for the protection of individuals, and the same is codified categorization of protectees. In Ramveer Upadhyay, the Honorable Supreme Court has observed, that is the paragraph, Malad, I placed, Malad, the earlier judgment. But kindly skips over the quotation, then kindly take 17. The aforesaid judgment of the Honorable Apex Court was relied upon by the division bench of the Allahabad High Court in Abhishek Tiwari versus UP, passed in so and so, so and so of the judgment are necessary to be quoted herein under. Then the quotation: a large number of private persons are being provided personal security, many who would consider as wastage of taxpayers' money. To a parliamentary question, the Minister of State Home replied to that the security for the President, Vice President, Prime Minister was provided according to the Blue Book. Though not stated in so many words, it was clear from the context that the security was given ex officio, that is, by virtue of the offices they held. It was told that the Union Ministers, the State Chief Ministers, and the judges of the Supreme Court and High Courts were provided positional or statutory security cover to facilitate impartial decision-making process. The security arrangements for other political personalities were made after careful assessment of the threats emanating from the terrorist militants, fundamentalists, outfits, and organized criminal gangs, and that the mechanics of security arrangement was prescribed in the Yellow Book. The degree of threat varies from individual to individual depending on factors such as nature of activity, status, and likely gains of terrorists, etc. Accordingly, categorized security cover of Z plus, Z, Y, and X is provided to them on the basis of the gravity of the threat. Thus, threat perception is assessed on the basis of threats emanating from various terrorists, militants, fundamentalists, outfits, and organized criminal gangs for some work done by the protectees in their public life and in national interest. Then next paragraph skips over one line. There could not be any dispute about the security of the President, Vice President, and Prime Minister, or the Union Ministers, State Chief Ministers, and judges of the Supreme Court and High Court, because they represent the core functioning and authority of the Indian state. There would be other political personalities who hold public offices and might have real threat from the terrorists, militants, and fundamentalists, outfits, and organized criminal gangs for the work done or being done in the interest of the nation by such political personality. Then Malav kindly skips over a few pages, but kindly takes paragraph 19. The gravity of threat in view of prospective apprehension of an individual protectees has to be analyzed periodically by the competent authority in order to rule out any such unfounded apprehension or otherwise. The competent authority has also to analyze the material to be supplied by the protectee or individual claiming security cover, enhancements in the security cover already provided in the addition to the security cover already provided. In the present bunch of cases, it is true that the security is a state subject and the competent authority has to evaluate the threat, if any, faced or perceived by an individual and individuals are protectees. This exercise has to be left to the competent authority for making lawful assessment of threat on the basis of the inputs to be provided by the state or central agencies. So, Malad, my endeavor to show these paragraphs, Malad, twofold. One is the issue with regard to the Yellow Book and the Blue Book. It's a set formula so that no discretion is applied. No one can tamper with that security cover. And the other one, Malad, is to leave it to the state that how to deal with these threat perceptions. Now, Malad, if it is interfered with, Malad, then that exercise by the authorities expert to do it, Malad, gets tampered with. But unless your lodges will find it to be too unreasonable, your lodges will not interfere with the conditions which has been imposed. Now, this is with regard to the trade and business. The other is, Malad, with regard to the other petitioner, perhaps for whom Mr. Bhattacharya was appearing. Now, Malad, he says that it is my property and I am not being able to reside therein. Now, Malad, here the question is that whether he has been deprived of the property itself or not. Malad, here also, 300A is subject to, Malad, reasonable restrictions. Similarly, as it was under 1905, when it was, Malad, a fundamental right, it was subject to reasonable restriction. Now also, Malad, various Supreme Courts have said that it is subject to reasonable restriction. But Malad, kindly see the language of 300A once. Malad, I'll read it out, Malad, for your lordship's kind convenience. Well, we cause our own difficulty, Malad, when we stop at saying that I have a right to property. My right to property has been hampered by the state. My right to property is same as my human rights. But Malad, what is that right to property? Person not to be deprived of the property. No person shall be deprived of his property save by authority of law. This is not deprivation. his land is not being acquired without a land acquisition law. His land is being regulated. Regulation is not deprivation. Malad, the other petitioner has mixed up his right to be not deprived as to right to be not regulated. His right to property is not unregulated. His right to property can be regulated. And again, Malad, whenever the question of regulation comes, the reasonability of the regulation comes. His right to property can be reasonably regulated. But it is not a case where his land has been taken over by the police authorities saying that no, it is near to his secretariat, you cannot build on that land. It is not that case. His case is not under 300A at all. There is not a case of deprivation at all. And the fact that his land can be reasonably regulated, but your lordship will kindly take one decision of Jharkhand, Malad, division bench of Jharkhand. The right to property was not meant to be understood that right to property means right to use the property in any manner whatsoever. Right to property is to have the property, not to use it in whichever way I feel, but even if it is at the competing claims of safety and security of the secretariat. It was not envisaged to be so. It should not be taken away. It should not be snatched away without any authority of law. Malad, kindly take the Jharkhand decision. Malad. This is 2024 1 High Court cases Jharkhand. High Court cases Jharkhand. Jharkhand 333. হ্যাঁ এসএসসি অনলাইন থেকে তো বার করেছি yes Malad kindly takes but the issue has been framed in 14 Roman 3. I'm not reading it, Malad. I'm sure they will read it when they want to distinguish it. So I will spare myself from reading it. But kindly takes paragraph 111. 111 to 115. The deprivation can take place in various ways such as destruction or confiscation or revocation of the property rights granted by a private proprietor or seizure of goods or immovable property from the possession of an individual or assumption or control of a business in exercise of police powers of the state. The deprivation is to be distinguished from restriction of the rights following from ownership. The Supreme Court in State of Bombay versus Bhanji Munji, wherein it has been observed that substantial deprivation is meant the sort of deprivation that substantially robs a man of his attributes of enjoyment, which normally accompany rights to or an interest in the property. The form is unessential. It is the substance that one must seek. For ready reference, paragraph 6 and 7 is quoted. I am skipping over that quotation. Kindly comes to 113. Next page. It is thus evident the admitted case of the respondent is the grievance against the restriction to be imposed in view of the guidelines dated 18 May 2011. They are also admitting the aforesaid restriction to be imposed but not on the basis of the guidelines dated 18 May 2011, rather on the basis of the guidelines dated 21st October 2016. Hence, the argument advanced on behalf of the learned counsel for the respondent so far as relates to depriving them from the right to hold the property is contrary to the pleading and the grounds. Hence, both the guidelines speak about restriction and not about the right to property. The applicability of the constitutional right guaranteed under Article 300A of the Constitution of India is only with respect to depriving the landholder from the land and
how much time, Mr. Banerjee, Mr. Bandyopadhyay, how much time?
Well, how much
time will you take?
Well, 5 minutes. Just to complete this judgment and one order of the Commissioner of Police, Malad, I'll show that these restrictions are otherwise there also. Or similar nature. The one I was making submission, Malad. The applicability of the constitutional right guaranteed, Malad, I'll continue today. Yes.
Let's finish it.
Yes, Malad.
It's just that I have a meeting at 4:45.
But I'll just, but within this time.
You, Mr. Banerjee, you don't have to, Mr. And then Mr. Chakravarti, you too.
My lord, we'll give reply after they are done, lord. We'll give a short
So
reply.
it will
lord.
take time.
Sometimes too, I'll take, lord. Because Mr. Bandyopadhyay is showing some judgment, I'll
I
have
have
to
a
deal.
4:45. Otherwise, I would have sat till 5:30. I could have finished. I've finished it today.
Well, 15 your lordship has kept the municipal tax matter.
Yes.
We can start after that, my lord, because because we are only giving reply to reply there. Learned advocate will give reply, should not take much time.
We can finish it that day.
Yes, both will be finished then.
Both will be finished.
Lord, we are here every day, lord. Whenever.
Any additional judgment, if I have to show, I'll give Mr. Chakraborty a copy.
Same see. And then we'll finish after yes.
But let both be 2 p.m. my lord.
Yeah, let's keep it around.
Yes.
If any, this was my last judgment today. If I add anything, I'll give Mr. Chakraborty a copy.
You're there in that one also. So
Yes.
2 p.m. will.
Lord, at least for these matters, we are getting my lord some time in the appellate side. Getting some time in the appellate side.
You have been very not fair.
Kindly do not record that I have concluded today, my lord. I'm
not-
concluding.
Hard at length.
Counsel for the
Yes.
Shashanya Bandyopadhyay.
Mr. Bandyopadhyay.
Listed for further hearing. Heard learned counsel for the state, Mr. Shashanya Bandyopadhyay. Listed for further hearing on the 15th at 2 p.m.
Do not support him. Stand by what you have taught us. Not to disturb in the middle. Judgment print kora. 15 2 p.m.
2:30 कर देते हैं.
अरे इलेक्ट्रॉन আছে তো পরে.
1 is 2, 1 is. We'll
15th,
keep it 2:30 p.m.
15th at 2:30.
Judgment print kora.
Pass the advocate general matter.
That is original side. This will be
কেন কার আছে লর্ড 50 কেন বলবে তো তুই চলে আসবি তার মধ্যে কি বলছিস বল বল
Mr. Sumitava, you don't have to do anything. Your boss is here. And the other one is right.
One
Yes.
Chakraborty is enough for us.
who is now invisible. I don't know where has he gone.
He was there.
He was there. He was disturbing him.
Leading me in a separate matter with his fixed books.
He will come.
That is leading me in a separate matter with his.
In that, Mr. Bhattacharya will argue. Here, Mr.
Yes.
Chakraborty will argue.
Mr. Bhattacharya will reach everywhere. He is omnipresent everywhere.
But little bit assistance we will give Mr. Chakraborty.
Yes.
We'll finish.
Great.